How's it going, Debbie?
Hey, good. How about you?
Oh, you know, I'm okay. Did you get in last night or this morning?
This morning, I was just over at Starbucks. Just like, I don't know, 8:50 or something like that. At Starbucks. So you saw that email from Steve?
Steve, yeah.
Yeah. Whatever. There's only two of us, I guess we can talk. If he's doing the sound, I guess we're not.
I know, is this?
Yeah, he's testing the sound.
Oh, okay.
Crazy. I shouldn't know what this area is. Should be on the go again.
Eileen is, we know that she's not available today.
All right, this is the meeting of the 2020 Governance in the Public Interest Task Force. I'm Alan Steinbrecher and I'm the chair. Welcome everyone, anyone who's watching or attending online. And Dag, would you please call the roll?
Of course. Chen, Cisneros.
Here.
De La Cruz. Duran.
Here.
Manning.
Here.
Saleg.
Here.
And Steinbrecher.
Here.
All right.
Great. First item on the agenda is the chair's report. I don't have any thing to report at this time, so I'll go directly to the call for public comment. Is there anyone online who would like to comment to this task force? No? Alrighty. There's no consent agenda, so next is item 3, business, and Dag, take it away.
Thank you. I'd like to engage in I hope no more than a half-hour level setting. I hear this term used in the IT world where you begin your meetings by making sure that everybody has the same information available to them, was privy to the same conversation, knew the key issues that are going to be considered in the meeting that they're having. And I think that the level setting is especially necessary for some of the reasons that I'll get into in the presentation on the level setting. We have 2 members who have not been at either of the meetings for reasons that I'll also get into in the level setting. I say I hope for no more than a half hour of level setting, and I hope that that's sufficient to sort of get us all oriented, because then I'm eager to turn the floor over to Professor David Studdard. A couple of you have already met him. He's not just a leading expert in the field of health law and empirical legal research. He's has a joint appointment at Stanford as both a professor of medicine and a professor of law. He received his master's and doctorate at Harvard University, doctorate of science from the School of Public Health. Has served with the RAND Corporation, received numerous awards and accolades and funding to conduct the research that he does on regulation of the medical profession. So I'm super eager to hear what he can share with us that we can learn from the medical profession that we might apply to the legal profession. So welcome, Professor Studdard.
Thank you. Thank you for having me.
So as the opening slide here indicates, what I want to just put out and make sure that we're all on the same page about has to do with the charge of the group, the background, the relationship of this work, this body of work to other state bar work that we're doing right now. Debbie pointed out to me at the planning meeting in January, he said, isn't that kind of what we're doing for the governance task force when we were looking at Professor Robertson's presentation? And you're exactly right. And I think making that relationship explicit will help inform like how we plan to go about our work. And then the timeline I think is critically important. I have some questions that I have put up as well to generate some conversation, but I also think just based on my preliminary discussions with Professor Studdard that there's going to be a lot here to think about and talk about. So the charge as will appear in the report that we write to the Supreme Court, the legislature, and the governor. You always begin these mandated reports with the charge, and this is the charge. And this task force is supposed to be convened every 3 years, and it's supposed to provide recommendations for enhancing the protection of the public and ensuring that the protection of the public is the highest priority in the licensing, regulation, and discipline of attorneys.
Don't take that away yet, Dag. I'm sorry. I'm gonna take a picture of it so I don't forget. Thank you.
I will be making these slides available as well as other resources. So I normally would not point to the composition of the group except that it changed. It changed between when we had our first meeting in September, where the Business and Professions Code at that time was out of date and reflected elected members of the Board of Trustees. We no longer have elected members of the Board of Trustees because we are now a more purely regulatory body. So at the September meeting, there was a little September and the November meeting. We were still sort of in this limbo with regard to the new fee bill passing and the changes to the fee bill that then changed the composition. This was the previous composition of the 7-member Governance and Public Interest Task Force, which included at the top there those 2 members who are elected members who as of September didn't even exist. This is the new composition, which explains why our representative of the governor's appointees, thank you, Jose, our representative, by default now this system sets it up so that both of the Senate's appointees and both of the Assembly's appointees, the public and the attorney member, are represented on the Governance and Public Interest Task Force, and then the 3 attorney members who, one of whom is the Supreme Court appointee, and then the chair of our board. So the previous reports of the Governance and the Public Interest Task Force, I need to point out here, I mentioned earlier that it's an every 3-year task force, and you'll see here that there aren't 3 years between 2016 and 2017. So the first bullet and the sub-bullet there explain in part why that was. I think it's fair to say that those reports were written at a time of crisis at the State Bar. The specific language that's in one of those reports is that the report was addressing the perception and the reality of an ineffectively managed discipline system. One indication of that was that the 2016 report was due in 2014. The previous leadership of the State Bar had determined, we don't really need to do that. It's in statute, it says you shall, but we don't really need to do that.
They were also dealing with some other more immediate crises at the time.
I don't know all of the background there. I think all of us know a piece of it. Maybe some of us know more of those pieces, but litigation and various other problems related to the leadership of the bar, and a great deal of a lack of confidence in our principal stakeholders, the legislature in particular. Really, we were getting hammered in the press, and the legislature was quite unhappy.
Suffice it to say that because it was a statutory mandate, there should have been a report in 2014, but there were, to their defense, the leadership at the time was overwhelmed by a number of crises, including the departure of the then executive director under difficult circumstances and so forth and so on. So as a result of that,
when the new leadership of the State Bar, Elizabeth Parker and Leah Wilson, were brought on in the fall of 2016, to really like reorient the bar and restructure the bar and try to regain confidence in the work of the bar, they saw that this mandate had not been fulfilled from 2014, and they took it up and they ran with it. So they ended up producing 2 reports in pretty quick succession. And I think it's important to note that those reports not only were written as companion pieces, but they were very inward focused, of necessity. They were focused on governance understood as the size, structure, and composition of the Board of Trustees. Looking at the hybrid nature of the bar, the fact that we were both an associational entity as well as a regulatory body, and the contradiction inherent in that, the potential conflicts of interest related to that. It looked at the proliferation of activities, a lot of mission creep in terms of like, why is it that the State Bar is doing as many things as it does? Confused reporting relationships within the organizational structure of the bar, and then also the proliferation of committees, commissions, and boards.
Doug,
Yes.
are those 2 reports available on the website?
They are, and I have them in a Dropbox folder that I linked the original members to, but I'm going to relink everybody to. So,
But it's on the website.
yes, and I'll distribute some materials following this meeting, not only some references that Professor Studdard pointed me to, but also some of these sort of background documents. So the response to the 2016 and 17 task force reports, the recommendations of the reports included separation of associational from regulatory functions, changes to the size, composition, and appointment of officers of the Board of Trustees, organizational streamlining, organizational downsizing. Let me stay on that one just long enough to say, mission accomplished?
Well, that's what I was, if I may, I was going through, I said, okay, 1's done, 2's done. I don't know enough about our organizational chart and specifically to say whether 3 and 4 are done, but it seems like.
I don't think you ever stop. Like,
Yeah.
you know, there are always kinks to be worked out and you know, little challenges that remain. But no, I would say you're correct that we've definitely done 1, we've definitely done 2, and we've done a lot by way of bullets 3 and 4, and we'll continue to do so. I think that's a never ending.
If I can just add to that. The 2016 report was written at a time and by people who still expected the bar to be unified. The change came in the 2016-2017 time period when it was finally determined that the best course of action was to separate. So the 2017 report actually was written at the same time, while we were still a unified bar, but was looking to how to handle that transition. So there were a lot, you will hear from time to time still reference to Appendix I, which was an appendix to the 2017 report, which went through all of the sub-entities and recommended which one should go with what's now the Consumer Lawyers Association and which should stay. And there was, as you can imagine, there were some at either end of the spectrum that were pretty easy calls, and then there were some in the middle that had really overlapping functions and so forth. But a lot of that's been done, but that was a very important, 2017 was an extremely important report in my view.
And then with respect to downsizing the organization itself, I guess the exception to that is the new positions that are being funded by the State Bar fees increase that the legislature passed for OCTC. Is that accurate?
Yeah, I think you've gotten a little bit ahead of the game. So in response to 2016-17, we didn't get the fee increase until not effective until January 1 of this year. So what I was thinking of both in terms of streamlining is that when you look at the sub-entity work, some of that work, the Appendix I work that Alan referenced, is related to like, why do we have volunteers, committees on volunteers performing a function that really can be performed in-house? That's not a function that requires sub-entities, committees, commissions, boards to perform. That should be performed in-house under guidelines, with clearer guidelines with regard to, so for example, moral character evaluation. This was a big issue with the Committee of Bar Examiners. Like, who's performing moral character evaluation? Why do we have the Committee of Bar Examiners, which should be setting policy direction, performing sort of an administrative function with regard to checking the boxes in terms of have you cleared your moral character evaluation?
I mean, not to drill on this too deeply, but just kind of by way of context. When it was a unified bar, a lot of the opportunities to be on committees and everything was sort of prized because it was way members could move up within the organization. So there was a lot of functions that had many volunteer members. As we changed to a regulatory agency, the need for those kind of volunteers went away. So that was part of the real difficulty, actually, in some ways, of making the changes. But there was organizational streamlining by getting rid of, transferring, not getting rid of, but transferring the certain functions to CLA, and also downsizing the number of people involved. Even though we still have volunteers, obviously, in certain of our sub-entities.
Thank you.
You know, based on your clarification, Al, I'm reminded, and I'll just mention that although I think it's pretty well taken for granted among the trustees at this point that it makes perfect sense that we would not be both an association supporting the interests of attorneys and a regulatory body. At the time, it was very controversial, and I think that the vote on the board of trustees was very narrowly decided in favor of separation. And the recommendation for separation in the 2016 report was part of a minority report that was issued. So there was both the majority report of the members of the Governance and Public Interest Task Force, which did not include that recommendation, and then a couple of people who were very adamant that separation of the regulatory and the associational components needed to happen.
So that happened just by a vote of the trustees, they did not go through the legislature to have.
Oh, it very much had to go through the legislature.
Okay.
I think we were writing a.
I don't think there was ever a vote.
I would say
Trustees.
it was more driven by the legislature. It was ultimately in the fee bill, I believe, in probably 2017, and I think that evolved as the 2017 task force was underway.
I just sort of remember hearing Hannah Beth Jackson at the public about something like this. So.
There was a lot going on at the time in a lot of different arenas.
It was complicated.
Be nice to get to a point where we don't have to remind ourselves of the context and the history
Yes.
every time we have a conversation.
Yes.
Not to denigrate anything that's happening here, but I feel like we're headed that way.
We're getting
getting
to
there.
that.
Yeah.
I'm hopeful.
Yeah.
So for the 2020 Governance and Public Interest Task Force, we held a meeting in September at the close of the previous board year, beginning of the new board year. And at that time, members expressed their interest in pivoting from that inward focus of the previous reports and looking more at the regulatory functions of the bar rather than its organizational structure. And looking forward rather than looking back. I would say it's really on those two dimensions in particular that we came to some agreement at the September meeting, is that that's the direction we wanted to go. And at the time, we also were looking at some of the work that was being done by the ADJOURN group in particular the access through technology and innovation of legal services work. And there was a lot of interest in looking at like how the work of this task force might build on that work. There were some interesting ideas related to legal regulation, possibility of opening up ownership of law firms to non-attorneys, the triple LT, the limited legal license technician issue, like whether that would be something to pursue, and also the use of artificial intelligence for performing of legal services. So these were some ideas that I think really excited the group in September when we had our first meeting, and staff committed at that time to conducting a literature review, a landscape review, and returning to the governance task force with recommendations. This is the transition to the next slide where I was really looking for like a sound effect, where like a record scratch, like nope, not going in that direction. Between the September meeting and the November meeting, we had heard from our stakeholders that the work that the access through technology and innovation of legal services work was not being warmly embraced, that there were concerns among many of our stakeholders and also among many in the attorney population about the direction that work was going. Concerns about non-attorney ownership of law firms, concern about use of technology, even the triple LT stuff, which we thought was maybe low-hanging fruit that we might like work on. I think we're even starting to get some pushback in that area. And so at the time of the November meeting, we started trying to chart a new course and identify options that were discussed at that time had to do with identifying regulatory gaps that pose a risk to public protection, looking at risk prevention, proactive data-driven approaches to regulation. And staff at that time were charged with investigating other jurisdictions and professions where risk-based regulation is being used and evaluating what we might borrow from these examples.
And I'm sorry, stakeholders are the Supreme Court and the legislature?
To name names, there are, yeah, those are the two that I would say are the
That's
most
what I
important to us. So this brings us to today and our current focus. We're hoping to learn from proactive regulation in other professions and other jurisdictions. Professor Studdard will be talking about what the legal profession can learn from data-driven approaches to regulating the medical profession. On March 5, we have scheduled a professor from the University of Arizona, a colleague of Professor Robertson's, who has written about efforts to predict attorney misconduct, attorney complaints in Australia. So we'll get both a cross-professional as well as a cross-national perspective between both of these. We then have a to-be-determined opportunity in April to ideally build off of what we've learned from these two meetings. And then we have a very tight deadline to get to May 15. We're supposed to submit this report. We must submit this report. So this will obviously constrain what we're going to do. And I think, I have a different slide where I talk a little bit about what I think we can do in the amount of time that's available to us. But let me take a couple of minutes to try to engage in just a little bit of conceptual clarification. I have not run any of this by the actual expert in the room, so I'll be curious to hear his thoughts about it. This is my best effort to read through some of the dense literature in the medical journals and to also think about this work in context of some of the work that we've already done. And then to step back and try to place that in the context of really the charge of this group, public protection, ensuring that public protection is front and center in the work of the State Bar.
Dag, so thinking about the schedule that you laid out, it seems to me by April we would need to be discussing the draft report.
Absolutely.
So I think that would fill in your to be determined.
Okay. I think you're right.
Yeah.
Yeah, because I think a draft report in April means that we then have some time to revise and supplement and reorganize as necessary and come up with a final report, say early in May. Sure, super. Yeah, I like filling in gaps.
I don't think we have much choice there, which is good. Get it done.
No, I don't know that more time will translate into better quality. I think that, if we have a focus, one of the slides I was thinking of putting up was the old saying that there's nothing more practical than a good theory. And if we have some clarity, some conceptual clarity about what we're interested in, then we can write a report that maybe identifies some future areas of research or operational exploration. The what is it question in terms of, my first conversation that I had with Professor Sklar in Arizona, I wasn't quite sure what to call it because I've seen it referred to as predictive, it's preventative, it could be proactive, it's certainly data-driven, and at one point I wanted to call it the triple P, it's the proactive, preventive, predictive, but in terms of looking at some of the literature that I've seen and also responding to Professor Robertson's report, I see the data being used for a couple of different things. One is to identify practitioners who are at risk of what the literature calls an adverse event. In our world, that would be at risk of a complaint, at risk of an investigation, at risk of discipline. So simply identifying somebody is itself an exercise. It's not, it's not in front of you. You have to actually dig into the data to pull it out and organize it and do some modeling on the data to get at whether you can identify practitioners who are at risk. Another thing that Professor Robertson pointed to, though, that I thought was interesting was using the data to evaluate the adverse event in context. The in context piece in part was used as a control to make sure that you're not looking at, say, attorneys who are working a lot and have a higher result simply due to the fact that they're working a lot, as opposed to attorneys maybe who are working part-time on a case here and there. That's a control issue, but he also proposed the possibility of using that information in context, like talking about the profession, the legal specialty of certain attorneys. Which legal specialties are more at risk of receiving complaints? Family law? Is it criminal? We don't really know because we haven't looked at the data in that way, and I think that it would involve some data, some recoding and some data mining of stuff that's not in the electronic record. It might involve some case file review. And then the other issue that I saw in terms of what it is using data to intervene. Once you've identified practitioners who might be at risk, once you've identified maybe key events in the life cycle or the career of an attorney, what is that event that might trigger an intervention? We've talked about this with regard to identifying attorneys who leave public sector and move into private practice, and the fact that they've probably never seen a client trust account before. They might be charged with managing one. Maybe if we could identify attorneys who are making that transition, that we would want to really impose an opportunity for them. Impose an opportunity, I've been in management too long, to give them client trust accounting information that they need to avoid running afoul of the rules of client trust accounting. So how this relates to other work that the bar is doing, this is the report from Professor Farkas that we looked at in the fall and that Professor Robertson was responding to. This was, this is partly the identification. We have done some identification of attorneys who are at risk. This was done for very different purposes, and I think really, if anything, what we're looking to do here is to eliminate those differences, not to use those differences to drive like our practices. We're trying to, if you look at this first slide here in terms of just the risk of a complaint, and looking at the average number of complaints organized between men and women, the top panel and the bottom panel, and then the race ethnicity categories across the columns there, you see right away that men are at greater risk than women, twice as likely to have received a complaint as women on average. And then the Black and Hispanic attorneys are at greater risk of receiving a complaint, both than the average and then in comparison to white attorneys. So this was sort of the first step in that work. We then looked at how that cycled through in the process of disbarment and probation. This is only the disbarment slide for the numbers. The probation numbers look very similar though. And once again, you see that the risk of disbarment for Black and Latino attorneys is much greater than the risk for white attorneys, white males in particular. But then when we ran the regression model, we found that those effects really disappeared. So the impact of race ethnicity was being driven, at least in terms of the statistical model, not by the race ethnicity of the attorneys, but rather by the number of investigations that are opened, the number of prior disciplines, and we're not really clear how this interaction effect works in terms of, well, what happens after that initial investigation is open, and how does that create some sort of like pathway that then attorneys are on that is difficult to get off of in terms of prior discipline. But representation by counsel became an important factor in that model as well. And then there's a whole range of different types of allegation codes, all of which have very small impacts, but that were statistically significant. It's not clear quite what to make of those. They're very big categories, and I don't have a lot, I'm not quite sure what to make of it, because they are statistically significant, but again, if you look at what's in any one of those categories of allegations, it could be any one of 15 to 20 different violations of the Business Professions Code. So how does this relate to public protection? I think that identification of at-risk attorneys makes perfect sense that it does. If you can predict who might run afoul of the rules of professional conduct, who might harm a client, that's useful information. It seems to me that intervening as well, once you've identified, intervening makes a lot of sense in terms of public protection. But it was this one that really, as I was trying to think this through, caught my attention in terms of contextualizing the circumstances of at-risk attorneys. And I want to problematize two slides that Professor Robertson used, and then I'm going to stop talking. This was one of Professor Robertson's slides. This was the contextualization of complaints, trying to understand not just the number of unprofessional behaviors, the example he's using here is failure to communicate, which could result in a complaint. But trying to understand that contextually in terms of, well, how many public contacts do you have? How many clients do you have? How many clients without recourse to, number of clients without recourse? Unfavorable outcomes. So he wanted to say that it's not just about the numerator in this equation. It's not just looking at individuals in terms of how many complaints that they've received. It's useful, as he was putting it, to understand, well, an attorney who has 10 complaints out of 500 unfavorable outcomes is probably doing a better job on average than an attorney who has 5 complaints out of 500 unfavorable outcomes. And I said that I wanted to problematize this because I think that there's an inherent tension between looking at generalities in terms of, and averages in this way, and what the Office of Chief Trial Counsel ultimately has to prosecute. It may not really matter if the attorney on the left is a better attorney if a complaint has been received and the attorney has harmed the public in some way, has violated the rules of professional conduct. I don't know that the Chief Trial Counsel's office can really take that into account. The one way where, and trying to think this through, the one way I was thinking that we might consider it as something that needs to be taken into account is if there is an inherent tension, say, in contextualizing the work of attorneys in different difficult practice settings, say because they do important work which fulfills a public protection function, and that we need to not disincentivize that work. Perhaps that's where contextualization can be said to be supportive of public protection and sits in tension with actually disbarring attorneys who violate the rules of professional conduct. But I wanted to raise that. Yes, Ruben?
Can we go back just one slide and define for me what is an unfavorable outcome? I mean, that's from the perspective of the client. Well, I'm assuming, seeing that there, that it's from the perspective of the client, but it's going to change based on the engagement, civil or criminal. It's going to change based on the transaction if it's civil. I mean, what if we're using that as a denominator, unfavorable outcomes, what is that universe of?
This is a great question. When I was talking this through with Steve Moad the other day, Steve Moad is one of our chief prosecutors in the prosecutor's office. He kind of shrugged and he said, we're not going to get complaints from people who have favorable outcomes. So he didn't define what it was. So there's maybe a little bit of a, I know when I see it kind of thing, that the only people who are going to make complaints are people who lose their case, who don't get the settlement that they're after, who, I don't know. So, but I think that's a good question, whether it's, but I do think it is from the client's perspective, is how he was reading it, and his perspective was that, yes, if a client is unhappy, those are the people who make the complaints. So I think for the denominator, we're not interested in the total volume of the attorney's work. We're interested in whether they're in a practice setting that makes it more likely that they're going to be dealing with negative outcomes for the client. So that would be, say, defense attorneys or, say, family law practitioners. I think that that's partly why you gravitate to those specialties, because you can see a lot of unhappy people in family law.
But there are probably a very small percentage, but I think there are complaints that are filed by judges or even other attorneys for the violation of certain rules, such as misrepresentation, whatever, right?
That's true. The vast majority of the work that comes into OCTC comes from complaining witnesses.
By clients.
Yeah, there is, I know that the Chief Trial Counsel's office has attempted to, encourage judicial officers to call out misconduct, and has provided contact information and alerted them to the procedures and policies to say, look, if you see misconduct, please let us know.
So I think the general statement, it comes from clients overwhelmingly, is correct, but there probably is a little bit of variation.
I guess what I'm having a hard time putting my arms around is we know about complaints. That's the top number. But unfavorable outcomes, what I think I heard Dag say was we know about those because of the complaints. So would the top number be the bottom number? And the professor shaking his head, so I look forward to being elucidated.
Yeah, I think you're exactly right. I don't want to
Please,
jump in.
no,
You can't measure the bottom number there. the way that I would think about the denominator here is it's really sort of two constructs. You know, one construct is what we would call an exposure measure, and that's just how much time you're spending in the practice that from which might come complaints. So, you know, the simplest example there is, you know, is it somebody who's working part-time or is it someone who's working full-time? All else equal, the person who's working full-time, if they have, you know, double the rate of complaints over an extended period of time, the person who's, they may actually be equivalent, those two practitioners. So that's a very basic idea of kind of just like exposure. But, you know, part-time, full-time doesn't really get at it, because what you might also want to know is, for example, client volume. Some people see a lot more clients. And these things are very hard for the regulator to measure. Insurers try to measure them sometimes, liability insurers, because they price that way. But typically what people end up doing is just resorting to some basic crude measures of those things. What does help, though, is if you can divide into practice types, because there tends to be some more homogeneity about practice types. The other part of the construct is not so much about exposure time, it's really about risk within that exposure. So certain types of practice, small claims tribunals, you know, litigation, personal injury litigation, and so forth, they're going to be much more likely to give rise to these interactions that will produce disputes and complaints than would, you know, M&A work where you're dealing with, you know, general counsel of a big company most of the time. So again, impossible to measure from the regulator's perspective, but, you know, splitting the population into practice groups definitely helps with this. That's not perfect, but we should just assume that the denominator in that fraction there is unmeasurable.
Okay, thank you. Sort of had that sense.
Yeah, it's a theory. It's a theory about what you would really want to adjust for to get apples and apples when you compare two lawyers in terms of their track record. We could never get to it, so, you know, we use these proxies.
Okay, thanks. Thank you, Dan.
The other slide of Professor Robertson's that I wanted to just pull out from his presentation and problematize a little bit was when we were looking at the question of the difference that we see, the importance of being represented by counsel when you are being charged with misconduct and or at risk of being disbarred, and that it mattered a lot. And as it was framed by Professor Robertson, because, again, we were looking at it from the perspective of disproportionate impact upon African American attorneys as a result of the fact that they were less likely to be represented. As Professor Robertson framed it, he was saying what we want to do for better outcomes is we want to move the outcomes of unrepresented attorneys more to be more similar to the outcomes of represented attorneys. I think when we step back from that particular research, though, and we're asking ourselves about what a good outcome is, it may be actually that a good outcome is that the represented attorneys look more like the unrepresented attorneys. Is it that represented, what have we brought over to the attorney discipline system many of the same features of the justice system writ large, where we have these due process protections in place that in practice favor people who can get representation in that litigation, the adversarial system as a whole sort of brought over to the regulatory system. And I think that this was a broader question that Professor Robertson had raised in private conversations, but that I wanted to introduce to this group, because I don't know how adversarial other systems are in the way that they process complaints, but I know that we are unique in that we have a state bar court. And I don't know how different that is, say, from an administrative law setting. But I do think that it's a question that should be posed. Maybe if you already know the answer and there's nothing there, we can move on. But I wanted to raise it as an issue in terms of, we're very unique. We have what seems to me to be a very, almost just transfer of this is the legal system. And it's very similar. I think that the prosecution of attorneys in the state bar discipline system is very similar to our legal system writ large. John?
Well, yeah, so, well, the state bar court structure is unusual for attorney regulation, and I think still is unique in the United States, because many attorney regulatory systems are essentially run by volunteers, so the decision makers are volunteers. The ultimate decider is usually the highest court in the state, as here. And we used to have a volunteer system prior to the state bar court. But I don't know, and I think the respondents here are all lawyers, and so they're trained in law, but the disciplinary system is a very unique environment, and so the typical lawyer really does need counsel to understand it. Our speaker probably knows more about this. I think medical board systems and other licensing systems they're different flavors of this, but they're still very legalistic. There's a high level of due process afforded to licensees. It's basically considered to be a property right, and that's the reason the standard of proof is so high. It's close to a criminal standard of proof. It's not quite there. So anyway, those are my reactions to what you said.
Okay,
Yeah.
so it sounds like there is, in other professions, that there are clear similarities in terms of that high burden of proof and.
Yeah, but they're very specialized, different, for example, medical board practice is specialized. It's a completely different specialty than state bar defense, because the subject matter is so different.
Although I wonder, and the professor can certainly tell me if I'm on the wrong track here, but my limited understanding of the disciplinary regulatory system for medical professionals places a high value on peer review, peer judgments. But in our system, that's what it is. It's judges who are lawyers elevated to the judgeship, being represented by lawyers and being prosecuted by lawyers and being adjudicated by lawyers, which is all peers. So I'd be interested to hear your thoughts on that.
Yeah, so there's different models in the medical board world, I'm not familiar with all 50 states, but I can tell you that the sort of main models are either that the medical board, an arm of the medical board sits as the adjudicatory body in proceedings, and there is a right of appeal from those decisions into the court system or into an ALJ, or the medical board acts as essentially the sort of prosecutorial arm in a case, does the investigation and brings the matter, and it's heard by an independent body. So there are two different models, and the second one tends to involve much more strict rules of evidence and so forth than the first.
It'd be interesting, we're probably jumping ahead, but why there are different outcomes when someone is represented versus not represented. Obviously, there's an inherent imbalance. I don't know, I'm just hypothesizing, but I assume that there is a imbalance in the system where prosecutors who spend their careers or a lot of time prosecuting cases in front of the state bar court have an advantage over an attorney who is appearing for the first time, let's say, representing him or herself. But does the represented attorney benefit from, taking advantage of certain arcane rules that really frustrate the actual imposition of discipline that should be imposed, or is the represented attorney benefiting from a check on prosecutorial bias in wrongdoing or otherwise? I mean, I could see a situation where, let's say hypothetically, we recommended that everybody who appears before the state bar court has representation of some kind. That might be the public perception that lawyers are getting other lawyers off. If we raise that, so I'm just kind of thrashing around here.
I suspect that there is an advantage to representation, but I think what you have to be careful about in looking at a chart like that is that you can't assume that the underlying merit of the two groups of cases are the same.
Mm-hmm.
There may be something about cases that involve lawyers who choose or for whatever reason end up going unrepresented, but also tends to involve matters that are less defensible and more likely to result in adverse findings. So there's a sort of unobserved variable there that could be really, really important. You know, what you'd really like to do to get that chart right is to say, let's take a bunch of cases that are all pretty similar as best we can tell in terms of their underlying merit. Now we'll try to see whether...
Well, it's interesting that you say that, because if you read the discipline reports in the weekly and the daily journal, there are a number of people who have discipline imposed who just choose not to ever appear. They just default. Yeah. And do they do that because it's overwhelming and it's unfortunate that they're being crushed by the system, or is it because they recognize that there's no reason to spend the time and money to defend themselves?
Yeah.
So, anyway.
And the last thing, well, not the last thing, but one thing that struck me is this concept of merit of the underlying issue. It would seem to me that some of the best evaluators of that, I'm not going to use the word judges, are going to be our employees, right? The people in OCTC who get the complaints, evaluate them, investigate them, evaluate them, and decide whether or not to prosecute. And my question is that our only source of information as to the underlying merit or the merit of the underlying issue? So I don't expect an answer, but it seems to me that that's a prominent question. Like, who's judging that? Who's judging what's meritorious?
I've spoken for too long, and so I'm going to conclude. I have some other pieces here, but I'm going to...
Can I take a 1-minute break?
Of course.
Let's take a 3-minute break.
Yes.
Okay. And that was a very good presentation. Thanks, Dave.
All right, thank you.
Thank you.
Good idea.
Public Interest Task Force, and I will note that not everybody's here. We're going to wait a minute. They just left. We'll be back. All right. We are reconvening the meeting of the 2020 Government and the Public Interest Task Force. And I'll note that all the members who answered present for the roll call initially are here, and we've been joined by Donna Hershkowitz, the interim executive director of the State Bar. So, Dave.
David. Thank you, Dag. Thanks for having me here. I'm going to stand, and I've got a few more pictures than Dag, so I'm probably just going to hang out by this screen here and tell you a little bit about this topic. What can the legal profession learn from data-driven approaches to regulating the medical profession? I will say one thing that Dag left out of my introduction was that I did start out my life as a practicing attorney, so I spent couple of years in a law firm, and then a year with the government. So even though most of this work and most of my work today is in the healthcare system, these issues are near and dear to my heart. And you know, most of my closest friends are practicing lawyers, so this is something that is quite familiar to me. So what I was going to talk to you about at DAG's request is just some of the work we've been doing over the last 6 or 7 years, mostly in the healthcare sector, thinking about complaints, negligence claims, disciplinary matters, and so forth. My junior colleagues are teaching me that what you're supposed to do with modern presentations is you cut to the bottom line straight away in your first slide. I like to keep people in suspense, but if this presentation has a bottom line, I would say that over the last 10 to 15 years, there is an emerging body of scholarship, still small but accelerating, that tries to help regulators of the health professions use data better to do what they do. And I think that work is still relatively immature, but it is improving. It is improving every year, and I think that the ability to take that work and apply it to other professions, the capacity to do that is extremely high. I mean, almost everything that Dave was talking about are things that we've thought about over the years as we've engaged in this work, and I think it's particularly true of the you know, so-called learned professions, thinking about lawyers and physicians, for example. There are a lot of parallels. Despite some of the differences in the institutional structures, I think that the sort of data challenges, the potential to use data in this way, there's a lot of resonance across the professions. Let me start with this slide. So it's a little hard to see, but the physician regulators are a pretty tight group, both at the national level and at the international level, and they get together once every 2 years for this International Conference of Medical Regulation, and it's very well attended. A lot of chairs of medical boards go to this thing. So this is a slide from the 2014 conference, which was held in Europe, and in the plenary session on the final day, they asked attendees, they polled attendees to find out what they thought the single biggest opportunity facing physician regulation was. 2/3 of them picked this one, using data to identify risk and prevent harm. The runner-up, that was about 2/3 of the vote, and the runner-up with 18% of the vote here is, this was about the use of AI and machine learning and so forth, rather the penetration of those technologies into the profession and what the regulators were going to do about it, something that Dag mentioned a few moments ago. So again, a lot of resonance, a lot of similarities, I think, as you look across these professions. So using data to identify risk and prevent harm. What exactly were the conference participants talking about here? You know, use of data, I would say, is one of several ideas that tends to get lumped under this sort of umbrella concept of risk-based regulation. You might have heard this, it's kind of a buzz term at the moment, risk-based regulation. So I thought it might be useful just to start by talking about what that is, what it means. Its meaning is actually pretty elastic, and I think it's used to mean many different things. One way it's used, which I sort of detest, is it's basically used to refer to any kind of regulation of a sector or an industry that involves risk, whether that's legal exposure, liability exposure, health risk, financial risk, reputational risk, all of the above. To me, that makes the term kind of meaningless. Most of the time a sector is regulated is because there is some kind of risk. So if we're going to refer to risk-based regulation as any of that kind of regulation, then it's basically all regulation, or very nearly all regulation. I think if you sift the literature, though, you can identify some features that really attach to this concept of risk-based regulation. One feature which won't surprise you is the idea that we would use data more in decision-making as a regulator. Sometimes this is called evidence-based decision-making. The idea here is not to throw away other bases for decision-making, like governing law, or experience, or considerations of fairness. But data gets a seat at the table, more so than it has in the past. another common thread in the concept of risk-based regulation is the idea that the regulator lifts its gaze from cases and thinks more about caseloads. Many regulators, including, I would suggest, regulators of professional misconduct, are almost exclusively focused on case-by-case decisions. The daily grind, involves close and careful consideration to the details of a particular case, and the working assumption is no two cases are exactly the same. And that's true, right? We understand that as lawyers. As I say to my students, our favourite sample size is 1. That's definitely a kind of worldview, I think, that has permeated many regulators. Now, there are lots of forces, ethics, rules of evidence, natural justice, and so forth, that compel that focus on the fine details of individual cases. A risk-based approach to regulation insists that in addition to that focus, some attention is paid to the wider picture. There are important changes going on with particular types of cases in the regulated population. Are there patterns that might change the way the regulator operates? They're all forms of thinking about case loads as opposed to cases. So once the jump is made beyond thinking about n equals 1, it's a pretty short step then to thinking about risks. Risks are really just probabilities. The chance that event X will occur, which you get by dividing the number of times X has occurred over Y, the number of times X could have occurred. That's a risk. So by definition, when we're talking about risk, we're talking about events in the plural, and we're not talking about single cases. And finally, risk-based regulation involves a shift in perspective for many regulators, especially, again, I think, regulators of the professions. And that new perspective is prospective. What's going to happen in the world next, as opposed to retrospective? We need to react to this thing that just happened and figure out what we're going to do about it. And the motivation for taking that prospective view, as opposed to the retrospective one, is that you want to try to get beyond that reactive posture. You want to try to figure out how to prevent things from happening, and the data and the caseload and the risk calculations, they're all going to help you do that. That's the idea. So here's a meme that you've probably seen before. I think it's helpful. Reactive regulation is the ambulance at the bottom of the cliff. Proactive regulation is the fence at the top. So how does a regulator think about developing and implementing a risk-based approach to regulation? There's not like a single answer. I can't give you a single answer to that question, but I can suggest to you that there are a number of follow-up questions that a regulator might want to ask itself. What type of risks do you care about the most? What's your budget? And so on. So let me try to illustrate. Suppose you had 4 possible programs you could implement, A, B, C, or D. And each program is going to tackle a particular kind of risky behaviour that the regulator cares about. The risk of that behaviour occurring varies depending on which risk the program is addressing, from 1%, let's say, to 7%. When the risk materialises, let's just assume it can kill people. That one works well in the health professions, maybe not so well in the legal profession, but let's just assume we're talking about deaths. Each of the programs is going to have a different level of benefit in terms of saved lives if you implement it. They have different costs, and then there's going to be a sort of a cost per life saved. This is really just taking the total program costs and dividing it by how many lives you're going to save. Now, you don't want to make your program choice based on what you've always done, which is, what does the board think is cool, or what's most acceptable to the regulated population? You want to do some risk-based regulation. So you have some options here. You could pick the program that addresses the biggest hazard. That would be program A, 1,000 deaths. You could pick the program that targets the largest risk in your population. That's going to be program D that will steer you towards that particular kind of outcome. Maybe you want the biggest lifesaver, irrespective of those other things. That's going to be program B. But you can't ignore the fact that program C is the cheapest. And if your budget is 300,000, well then the other 3 programs are going to be off the table. So there isn't really a right answer here. It depends on your priorities and your budget. But the point here is to say that if you set up some kind of grid that looks vaguely like that and you think about your options in relation to these kinds of considerations, you have entered the world of risk-based regulation. You're starting to think about your intervention points and your programs along these lines. So a growing number of regulators are doing this. To give you a few examples, agencies that deal with child protection and domestic violence in a number of states are now developing algorithms that essentially give them a probability of recidivism among mostly male offenders who are back living at home. And they prioritize their resource allocation based on which offenders, again, using a variety of variables, the original offence, how long they've been back at home, who's in the house, and so forth. They are directing their resources based on these algorithms. Several police departments across the country, including LAPD, are using these kinds of prediction models to select times and geographic locations for their beat cops to hang out at. And these models really just come from geocoded data on where crime and arrests are happening around the city. A colleague of mine at Stanford Law School, Alison Morantz, has been working with the Mine Safety and Health Administration. This is the federal agency that looks after mine safety, to help them kind of structure their inspection schedules, because they can't get to all mines every year, they do them every few years, but to prioritise the schedules based on which mines they think are most likely to have accidents. So she's built this big model, and there's all sorts of interesting variables in this model: workers' compensation claims, absenteeism, near misses, scores from previous inspections, and so forth. And the administration is now trying to arrange their schedule, not on a we'll come to you every 3 years type of basis, but rather we'll come to some mines once every 6 months, and other mines we'll let them go 5 years. So the promise of risk-based regulation, and much of this I want to suggest to you is unfulfilled at this point. This is more about the possibilities. Are really to allow identification of practitioners who are in need of support at an early stage. And I think this one's really, really important, because what we tend to think about with disciplinary structures is that we're getting to people at a stage where we need to decide whether it's time to be punitive or not. One of the sort of glimmers of I think, potential for risk-based regulation in this area is it's a different conversation if you get to a practitioner early in their track record, and it can be a more collaborative relationship that the regulator has in terms of trying to prevent that practitioner from further behavioural problems. There's an idea that risk-based regulation is a better way to target scarce resources. So, the old sort of command and control style of regulation is that you regulate your population uniformly. Everyone's a potential risk, and so you need to make sure that you're sort of thorough in getting to every corner of your regulated population. That is not the approach of risk-based regulation. And I think you can tell from these examples I gave, the entire premise of these is to target particular parts of your regulated population that you think pose the most risk, and data is going to help you do that. And finally, the overarching mission of these professional regulators, like you all, is to protect the public from harm. So it's interesting. I looked at these this morning on my way into the city, and I developed this list based on the work we've been doing with the health professions. I'm not sure I'd change one word of that in thinking about the legal profession. So let me talk a little bit about some of the work we've been doing in this area. We started in about 2011, and again, our main focus has been the health professions and the health regulators. Although we did recently I was part of a group that completed this project with the Victorian Legal Services Board, and I think Tara is going to come and talk to you about that project at a later meeting. So I'll sort of push that work aside. I keep using the we, that's kind of like not the royal we. There is a group of investigators here who have kind of worked on these projects over the years. Sort of like session musicians, they kind of rotate in and out depending on the project. But they're a really talented group, and I want to recognise them. The sort of core members of this group really have been Matt Spittle, who's an Australian statistician who's very interested in these issues, and Marie Bismarck, who's a Kiwi MD-JD, who's been working on these issues for many years. They were both fellows in my group at the University of Melbourne back in 2008, 2009, 2010. A couple of other things to say, to set the stage for sort of talking about this work. Australia is a great place to do this work on the health professions. It used to have a proliferation of boards for the health professions. I think there are 14 regulated health professions in Australia. We talk about physicians a lot, but of course there's physical therapists and nurses and a variety of others. So each of Australia's 6 states had a board for each of those professions. So there were 130 boards or something. In 2010, they were all brought together under one common scheme. So there's a central administrative structure that services all the boards. Each of the professions has their own board still, but there's no longer state chapters. It's a nationally consolidated system. It's interesting, the motivation for it had nothing to do with discipline. It was more about mobility, the ability of practitioners to move across state lines and practice and address workforce shortages in different places. But it's turned out to be a real boon for research because now all of the information on these professions is brought together in one place, and the data systems are much more sophisticated than they used to be. Our research has really distilled down to focus on a particular question. We look at the question in different ways in different projects, but really this question, which we call the prediction challenge, is, among all practitioners who are the subject of a complaint or a malpractice claim or a disciplinary matter, whatever the outcome we're looking at, is it possible to use data that's routinely collected by the regulator to accurately predict who'll be back with another complaint or claim within 2 years? So that's a somewhat different question than the one that Dag was talking about. There's also a question about just general frequency measures in the population. Which groups are experiencing the most claims? I think there's a variety of interesting policy questions you can get at by looking at that. But we feel like we've kind of moved beyond that question now. That question is interesting, but its main limitation is it doesn't necessarily point you towards an intervention. It tells you there may be a problem in a particular area. It might sort of raise a little flashing light that there may be a problem with representation or with attorneys of colour appearing more often in proceedings, but it doesn't obviously tell you what to do about that. We gravitated towards this question over the years because this is a question that the regulator is really a foothold or an opening for the regulator to take a more proactive role in regulation. It's also the case that whatever prediction, data-driven approach you take, it's unlikely that you're going to be doing anything substantive with practitioners who have never experienced a complaint or a claim or any kind of behavioural issue. It would be a weird conversation to go to a practitioner and say, we realise you've never been in trouble, but we feel you're at risk of being in trouble, and therefore we'd like you to do the following continuing education course. That's just not a conversation that regulators want to have. On the other hand, once a practitioner has come to you as a regulator several times with concerns, it's a different kind of conversation. So that's why our focus has been on subsequent events, conditional on having at least one event. We're now interested in sort of keeping practitioners out of trouble for future events. The path we've taken to answering this question has not been straight, but I think we've learned a lot along the way. And one of the things we've learned is that for a regulator to be able to answer this question in the affirmative, that it is possible to do this, there's a basic set of conditions that need to be present. You could think about these as kind of like prerequisites for useful risk-based regulation. And I actually just wanted to structure my sort of sifting of the research around these questions. It's a bit of an odd way to do it, but as I go, I hope it'll start to make sense. The first question is really like an early pressure test of whether prediction is even a possibility for you as a regulator. If your data fails this test, then you can stop. There's no need to go any further and try to answer this question. You already have your answer. So what do we mean by this? The events of interest in the regulated population must have a distribution that is amenable to prediction. So what is that? What is it for it to be amenable to prediction? So let's assume that we're talking about disciplinary matters or misconduct complaints. Here are two possible scenarios, both of which essentially foreclose any possibility that you'll be able to do risk prediction effectively. Scenario one, imagine that you regulate 100 practitioners and 2 of those practitioners experience several complaints, say 3 complaints, over some multi-year period, let's say 10 years. You almost certainly can't predict complaint risk in your population. And the reason is that they're just too rare. It's a rarity problem. Of course, in the real world, the rarity of complaints might be a good thing, but for prediction, it's not a good thing. Scenario 2 is you regulate 100 physicians again, and you get plenty of complaints. Let's say you get 70 complaints over some period of time, 5 years. This time, however, your complaint distribution is very different because what happens is that 70 practitioners each experience 1 complaint. Again, this is almost certainly an indication that you won't be able to predict future complaints. We call this one the wide distribution problem. In several studies of misconduct complaints in Australia, we've found that physicians do great on both of these scores. They don't have the complaints aren't too rare and they're not too widely distributed. But other types of health practitioners are more of a mixed bag. Nurses generally don't pass this test and they break down here. Complaints are just too rare against nurses. They're a huge population. There are plenty of complaints, but spread over a population of several 100,000 practitioners, prediction is not possible. Pharmacists are somewhere in between. It is possible to do it. They don't fail, obviously, at the rarity or the wide distribution test, but they're much less amenable to it than physicians. Let's talk a little bit more about this wide distribution problem. So this is the scattering of complaints across many different practitioners, such that very few practitioners have multiples. The opposite of that, of course, is that there's clustering of complaints within particular individuals. You might call it the frequent flyer issue. We do. A good deal of our work has focused on frequent flyers. Is it a thing? Is there a lot of clustering of complaints? Well, in 3 very different studies, one looking at misconduct complaints against Australian physicians, one looking at paid malpractice claims against US physicians, a national study, and one looking at complaints against lawyers. This is the SCLAR study. We consistently find very large amounts of clustering that would surprise you, I think. So over a 10-year period, each of these is basically gathered over a 10-year period. 3% of Australian physicians account for about half of all complaints. 2% of US physicians account for 39% of all paid claims. And in the state of Victoria, 4% of lawyers account for nearly 60% of all complaints. In other words, for these events and these populations, frequent flyers not only exist, but they are a big part of the story. They are a big part of the overall burden of complaints that the regulator is seeing. That sounds troubling, but for those of us who do prediction, that's fantastic. They're excellent conditions for prediction. It's also worth noting here, I think, we're talking about different kinds of events here. Complaints and malpractice claims, Australia, the United States, physicians, lawyers. Look how similar the clustering phenomenon is. It really does sort of, every time we see this, and we've seen it many times now, it almost starts to feel like a law of nature. There is a certain amount of clustering that goes on within these populations. So one thing I like to ask regulators of the professions when I give talks like this, malpractice insurers, hospital complaints organisations, what does your curve look like? That sounds indecent, but we like to plot these distributions along a curve. And there are really two questions here. How frequent are the events of interest in your regulated population? And then the secondary question is, how are those events distributed across the population? What I find is that many regulators can answer the first question because they develop those statistics for annual reports and such, but very few of them can answer the second question. I want to suggest that even if you never go down the path of prediction and risk-based regulation, it's worth knowing the answer to the second question. It's worth knowing what that clustering phenomenon looks like in your population. My bet is it won't look all that different to this. Okay, let's say we've passed that pre-testing. Now we can start moving closer to the sort of prediction that could be useful. So now we want to ask who's at particularly high risk of claims or events that we care about. Complaints. The claims or the complaints haven't come yet, but we want to possibly intervene before they do to prevent them. So we need to know who in our regulated population is at risk of these things. Now the standard way of addressing that who question, starting to hone in on the who, is to develop groups of people and look for distinctive characteristics. Characteristics that are strongly and significantly associated with the risk that you care about. Now those characteristics might belong to the practitioner, they might belong to the practice environment, the firm or the particular environment they're practicing in, or it may belong to the event itself. Notice the qualifier here, routinely collected. This gets to a point that came up when Dag was talking earlier. There are lots of characteristics we would love to include in these kinds of algorithms. Traits like the practitioner's communication skills, the practitioner's empathy or insight. Having looked at thousands of these cases over the years, I know that those things really, really matter. I'd love to do a study of them. But these kinds of things are really, really hard to measure, and they're impossible to gather at the regulator level. So the routinely collected requirement is going to demand that the regulator be able to get this information on all of the regulated population, not just the people that come forward, to your point earlier, Ruben, not just the people that come forward with complaints, but the background population as well. So for this to be useful in a prediction model, it's going to have to be something that comes in routinely, or that can be supplemented to what you already collect without creating a great burden on the regulated population. So where does that get us to? It typically gets us to some basic demographic characteristics like sex and age and specialty or practice area, practice location, maybe firm type. It sounds basic, and you might start thinking, well, okay, so maybe this prediction thing is not so useful after all. They don't sound like the sorts of things that we really care about, the sorts of things that really explain those frequent flyers. But the point I want to make is that prediction doesn't require you to actually know the thing that you care most about. You can do pretty well working with simpler, observable kind of characteristics if those characteristics are strongly correlated enough with the thing that you really care about. So to illustrate, I want to show you results from two studies. One, identifying physician characteristics associated with risks of future complaints, and the other identifying physician characteristics associated with risks of future malpractice claims. One from Australia, the other from the United States. So in analyses that adjust for most of the variables that a typical regulator captures in their administrative data systems, so these are adjusted for age and specialty and lots of other things. What we found is that physician sex or gender is associated with the risk of additional events. All else equal, including, by the way, practice volume and that part-time, full-time thing we were talking about, male physicians who experience a complaint have a 36% higher risk than female physicians who experience a complaint of returning with another complaint in 2 years. The same goes for malpractice claims. It's about 38% higher there. On the other hand, so gender is a risk factor for repeated events, in other words, independent of these other characteristics. This, by the way, is a consistent finding across all malpractice research in the medical sphere, all complaint research in the medical sphere. There are now sort of systematic reviews identifying this as a very, very consistent finding. We could talk about why that is, but that is fairly evident at this point. On the other hand, practice location, whether you practice in a city area or a regional or rural area, that doesn't seem to be associated with risk of future complaints. Risk varies with age too, although this is more of a mixed bag. Risks of additional complaints seem to arise with age, but risk of additional malpractice claims has a somewhat inconsistent relationship with age. Risk of accruing multiple complaints and claims varies very substantially. It wouldn't surprise you to know by physician specialty. The risks you see here, so this is risks of another event, conditional on having had one or more. And these are the specialties that we're looking at, and it's all relative to internal medicine, which is the largest practice group. So, for example, plastic surgeons' risk of additional complaints after adjusting for gender and age and where they're practicing is more than double that of internal medicine physicians. An anesthesiologist's risk, on the other hand, is about 30% lower. Again, I think it's striking here, we're looking at different kinds of events in different countries, but very consistent across these specialty groups. But in every model of future complaint or claim risk that we have ever run, there is one variable that turns out to be much, much more strongly associated with future risk than any other, and that is, I open the floor to guesses. It's not a personal characteristic like sex or age or specialty. It's event history. Compared to physicians who have accrued just one complaint or can claim in their careers, physicians who already have two are about twice as likely to be the subject of another within 2 years. Physicians who've already accrued 5 or more are about 12 times more likely to be back within 2 years. This sort of is another dimension of the clustering phenomenon that we were talking about earlier. And once again, it's very similar. This looks like it's kind of made up, but these are 2 different events in 2 different countries, and they're extremely similar. In more recent work, we've started to look at the relationship between practice size and risk event. For example, in one study, we followed a group of practitioners over time and found that as physicians accumulated malpractice claims, their odds of moving into either a smaller practice or a solo practice were substantially higher. Essentially, it was a dose-response relationship. The more of these events they accumulated, the more likely they were to be enter into small or solo practices, which actually is kind of a risk when you think about it from a regulator's perspective, because in a solo practice, they may well not have the kind of support structures or the peer oversight that you want these particular kinds of practitioners to have. The study of lawyers, just to give you a preview of what Tara will talk about, we find substantially higher complaint risk among those in solo and small practices. Again, adjusting for age, gender, and other things that we know are relevant. I want to just return to a point I made earlier on. I've been highlighting, these routinely collected variables and the associations they have with future risk. Most of the factors we've been talking about are demographic, but there are these other things that we're really pretty sure are likely to be associated with a practitioner's risk of complaints and repetition. And they can loosely be grouped under 2 headings. What the medical field have called personality traits and disruption events. The distinction between those 2 is not entirely clear. The way I would characterize it is traits are more about sort of who a person is and how they behave in some kind of consistent way. So for example, someone who just doesn't communicate well or keep records well or lacks insight or is arrogant You can often, by the way, see this in not only the way they deal with clients, but in the way they deal with the regulator when matters come before the regulator. Personal disruption is more about things that are happening to the practitioner. So this would be, for example, a marriage breakdown, a period of substance abuse, all of which we think pretty strongly can be risk factors for complaints and behavioural problems. Both sets of factors are really important, but they're just not that helpful for risk prediction, again, because we can't collect these things at the population level. Okay, next step. We want to move from these variables or sets of variables that have associations with the risk to get to variables that actually predict risk. Well, what's the difference there? Well, these terms are often conflated, including by researchers who should know better, but there are some important differences, and maybe the best way to explain the difference here is to just use an example. So, hundreds of studies have shown that clinical depression is a major risk factor for suicide. Those who have bipolar or schizophrenia are up to 100 times more likely to attempt suicide than people who don't have those conditions. But it has never proven possible, and likely never will prove possible, to predict who among those who have depression will go on to attempt suicide. There's been many attempts to try to do this, and it just hasn't proved to be statistically possible. Why? Well, part of the answer is the rarity problem that I mentioned earlier. Clinical depression is very common in the population. Up to 15 or 20% of the population may have a diagnosable depressive condition. But suicide is extremely rare, even among that population. So although we can see this association between these two things, we can't actually say, okay, now we're going to intervene. We're going to implement an intervention that grabs people who are at extremely high risk of suicide and does close case management or confines them or does something. Never worked, never possible to work because of this weak prediction in the population. So once a set of variables with strong association is identified, you've crossed the first barrier, but now we need to build an actual prediction algorithm and test how well it works in the population. So I'm happy to talk about the steps of the prediction model building process. There's a sort of a well-trodden path here. We're not inventing this. We're following this has been developed over decades, and this is the prediction algorithms that clinicians use in all sorts of ways to deliver healthcare. Maybe it's probably just most useful to just cut to the bottom line and tell you what this process, this is mostly statistical analysis, what it produces. What this produces in the work that we've been doing is essentially a scoring algorithm. Each time a complaint or claim comes into the regulator, the practitioner's risk of another complaint within 2 years is calculated by applying the algorithm. It's actually not a complicated, developing it is a bit complicated, but actually applying it at the caseload management end is not that difficult. So in our work with doctors, we call this thing the PRONE score, probability of new event score, and it's a simple score that runs from 1 to 20. It was designed for this Australian regulator of the health professions. The PRONE score uses 5 variables, the one that we developed for physicians, and this was a process of weeding out the ones that work really well in the prediction environment and ones that don't work so well. The 5 variables, in case you're interested in this, are number of prior complaints, not surprisingly, the time since the last complaint, sex, profession or specialty, and age. So those 5 variables together are used with different weights to produce a score. So a female physician aged 30 with her first complaint would get a PRONE score of 1 in our algorithm. And that, in the population, represents a 15% chance that she'd be the subject of another complaint within 2 years. Consider another practitioner, a male plastic surgeon, who receives his 9th complaint in less than 6 months. He gets a PRONE score of 17. And what that represents in the population is more than a 90% chance that he'll be back again within 2 years with another complaint. So we developed this on physicians, and we've expanded it now to some of the other health professions. And it's interesting. It works well for some and not for others. So this chart is one way of looking at how accurately it predicts risk for 12 regulated professions in Australia. And we're asking the following question here. When a practitioner receives a score, whatever the score may be, that's at the 90th percentile for their profession. So they're in the top 10%, if you like, of people who have scores in the regulated population. How likely is the practitioner in that profession to be back again within 2 years? And it does really, really well for physicians and dentists. So 90% of the time, if you're at the 90th percentile of your score, you're going to be back. And we can validate that on the population. Chiropractors and psychologists, it works pretty well as also, but pharmacists, 40% of the time, it's going to get it right. Is that going to be good enough to operationalize? That's a question for the regulator. And for nurses and midwives, it's pretty dismal. I don't think any regulator would want to operationalize a predictive algorithm that got it right 10% of the time. So the final step then, and Dag mentioned it, is, you know, any kind of prediction algorithm like this has to connect to something. The way I would think about it is that you know, prediction is a means to an end. It's not an end in itself. To be useful to the regulator, it needs to be the front end of something, of some intervention structure that's going to help ameliorate risk in your population. So what that is going to be very regulator dependent. But there has been some work in this area by regulatory scholars and so forth in thinking about just how you would structure a set of interventions that would map onto some kind of prediction algorithm. So, you know, we can think back to this chart where we look across physician groups and we realize that the algorithm works really well for some and not for others. Now this is at the 90th percentile. What if we were at the 50th percentile? Well, this is going to drop down a little bit, so we're going to be less sure. We're going to have some false positives there. Whatever we're going to intervene on people who reach a certain score threshold, but we're going to be conscious of the fact that some of those people actually wouldn't have come back. It may be a self-rectifying issue. So we've got to be careful. The lower we go down here, we've got to be careful about what it is we're doing. And so, you know, that's why regulatory theorists have sort of thought about this as kind of like a sort of a pyramid structure or a hierarchy. You know, you could have quite a high tolerance for intervention that is overreaching if it's a fairly unintrusive one. Simply sending a letter to a practitioner and notifying her or him that I have an X% chance risk according to our internal calculations of having another issue within the next 2 years. And you can move up through other kinds of interventions, you know, a tap on the shoulder conversation from a colleague, some rather heavily suggested educational interventions, perhaps targeted to particular issues that are coming through in complaints, and finally a sanction. You know, as you move up this pyramid, you're going to have less and less tolerance for that risk prediction getting it wrong. So I thought I would just maybe end with kind of some challenges that we've seen with regulators as they've kind of tried to wrap their minds around this novel way of thinking about things. And the big one really is just like how we can possibly do this given all the other things we do. And that's a question of just sort of resources and staff that could implement something like this, having the right kind of data, and then having the right technical expertise to kind of at least build the initial model that allows the frontline staff to you know, implement an algorithm. This is just beyond the capability of many regulators, even if they outsource some of these functions. Another question we've come across, which I think is really interesting, and it sounds like you've been thinking about some of the same issues, is, you know, from a statistical standpoint, the answer to the question, what would you like to put in the algorithm, is anything that predicts risk and which the regulator has. But in the real world, there are reasons you may not want to put certain things in the algorithm. Race, gender. You may make a principled decision that regardless of their predictive value, we are not going to be able to defend an algorithm that includes this kind of parameter. So you may give away a certain amount of predictive value if you make that decision, but that may be the only publicly defensible stance you can take. And then finally, it's the sort of Colin Powell thing. If you break it, you own it. If you have a prediction algorithm that works well, but you don't have a suite of interventions ready to go, you're in a precarious spot as a regulator, because now you know. You know about a segment of your regulated population that has an extremely high risk of perpetrating misconduct in the foreseeable future, being back with another complaint, and you didn't do anything about it. So what we have sort of tried to say to regulators we've worked with is, these things need to be developed simultaneously, and if this is not anywhere near ready to go, then you might want to hold back a little bit on the prediction side. From a risk management point of view, that seems like the right way to go. So I've talked a lot. Maybe I'll stop and be very happy to have a conversation about some of that material.
Questions?
I have a comment. I come from a law enforcement background, and we do threat assessment. And so some of the things you're talking about here is exactly what we do, because I worked at the Capitol, so there's always threats against the members, the governor, it's daily. And we have to do that sort of threat assessment as to where they are, where their personal, character, what's going on with them. Did your wife leave you last week? That kind of thing. You always have to assess that kind of thing. We don't do it to this extent that we can predict anything. But if they do have, like, it's called the DEETS 10, if they do have 5 of these things here, our intervention a lot of times was that, you know what, you're not feeling so good, give us a call. And so there would be people in my office who would talk to people who had a certain amount, we felt had a certain amount of risk involved with them, that they were threatening a member's staff down in their district or something, that, okay, you don't have to call Senator so-and-so's office anymore, because they don't seem to be able to help you, but talk to me. And so we talked to people that are in prison that would call us, and just sort of keep talking to them. Sometimes they just want somebody to hear them, but that sort of trying to try that intervention. Well, we did a lot of that. We did a lot of that intervention. We sort of identified this person. We don't know that they're going to do anything, but they're talking kind of crazy, and so let's see how we intervene to keep them from going to that next step.
And how did you come up with the sort of checklist of things that you were looking for? Was that just experience and impressionistic?
I think that was data driven.
Oh, it was?
Yeah, in terms of people who ended up being either committing an act that sent them to prison, or even if it didn't send them to prison, or if they ended up dead, or they ended up whatever. There's a data, because in law enforcement there's a lot of data.
Yeah.
There's a lot of data you can mine, especially from jails and that kind of thing.
Yeah.
So some of this stuff really didn't think of it this way exactly, but we did do a lot of that kind of threat assessment, data driven. Personal traits were really big. Yeah. But it's still a rare thing. It's in each individual person kind of thing.
Yeah. That's interesting. Yeah. Law enforcement is in a number of parts of the country really, really interested in this stuff and in machine learning and in thinking about, because they do have good data. They do suffer a little bit sometimes from the numerator problem that we were talking about earlier, which is that they're very good at identifying these characteristics in arrest data, for example, or in people who have attempted to do but in order to get the really good prediction, what you need to get also is the folks who had some of these characteristics but then didn't go on to and that's always harder to find.
It is harder. It's harder to find, and what's really happening now that's really driving a lot of things is there's so many lone wolves. There's so many people who have done nothing, and then when you do see them, they've just shot 9 people, but they never were on anybody's radar.
Yeah.
Because we monitor a lot of people. We do, my office, CHP, we work with the Secret Service. There's just a lot of people who are usually are multiple. The thing is, a lot of them are multiple harassers. They don't like the city councilman, they don't like the president, and so they're shooting things to all of them. And so we would sort of talk about who these people were and who was going to watch them and who was sort of monitoring them.
Yeah. That is sort of interesting, and you know, I guess the question in those instances is this a sort of a failure of surveillance and information gathering? In other words, there were signals that we just didn't pick
a lot
up?
of times there are signals, but a lot of times the signals are with their family and friends
Yeah.
who don't see them.
That makes sense.
Yeah, he'll never do that. I don't
Yeah.
think he's a good guy. Yeah, he'll figure it out. Yeah.
That's interesting.
I think this is fascinating stuff. You showed the three, you said don't go on to, don't do the prediction if you're not ready to have the interventions.
Yeah.
Can you talk about what some of the, in some of the examples in industries you talked about what effective interventions actually were?
Yeah.
And what were the outcomes of invoking those interventions? Did that 90% likely to repeat drop to by half? Did it drop to nothing?
Yeah.
You know, what?
So that hasn't been tested. So that's kind of at the stage of the work that we're at, which is that we would love to do a randomized controlled trial, you know, like applying these algorithms and launching these interventions on a randomly selected population and see how well they work. There's actually, even in the medical sphere where people have been talking about these issues for probably longer than they have in the legal sphere, 20, 25 years, there are a range of interventions out there. There's actually a little niche business where these consulting companies come in and help you intervene with problem practitioners. Disruptive practitioners, I guess, is the term of art. But there's very few good evaluations of them. To the best of my knowledge, there's no randomized trials of these things. There's anecdotal evidence that they work quite well. Probably the best and most rigorous program around the country is a program developed out of Vanderbilt University for physicians. You know, it is this pyramid. They have designed their own pyramid, and it's ascending hierarchy of interventions that starts with fairly unintrusive interventions at a low point of risk, and then starts to elevate as you move through higher levels of risk. And I can tell you that some of the interventions at the low level are what do they call it? They call it a tap on the shoulder and a coffee with a colleague or something like that, where a senior surgeon, for example, might who doesn't work with the person of interest, might go to that person and have a series of meetings and a discussion about what they're doing and what they could do better. And then at later stages of the process, if the person continues to have complaints that cause problems, it may move to a sort of a monitored process of a practice, such that they're not able to do certain kinds of treatments without another surgeon in the room, or if they're consulting with young female patients, they need to have another practitioner in the room. So quite interventionist, but again, short of practice suspension, and then all the way, by the time you get to sort of practice suspension, you're probably at the medical board at that stage. So this is called the PARS system, and it's been implemented in about 40 hospitals. There's some encouraging data coming through from this, but it's still not, I can't tell you that it's a clearly efficacious program.
But then back to your 3-arrow thing.
Yeah.
So if you say that you haven't tested the interventions or done the random control trial of that, then you haven't done the third bar? You don't know? There are no evaluative study results yet?
There's some, but they're not.
You say, this is what you say to get the full picture.
Yeah, I mean, I don't think you need to wait for evaluation necessarily to move towards an intervention. Because I think there are certain kinds of interventions that intuitively make sense. You may not want to continue them if after 3 or 4 years you decide that they're not effective. Really, what I had in mind here with the evaluation piece is that what we're always saying as researchers is when you design your interventions and roll them out, include an evaluation component in them, so that you're not just tethering yourself to a type of intervention that doesn't work well. But I think what Jerry Hickson at Vanderbilt and others would say is, look, there are a bunch of things here that we can do based on identified risk that we feel confident about, that makes sense. And we want to evaluate them, but we don't want to wait necessarily for that evaluation to come in before we roll them out. But yeah, my cautionary note here was really about, if you have nothing in this space, if you're not ready to do something based on these risk scores you're getting, then the train may be leaving the station a little bit early.
So I would say it makes me think of two things that we're working on right now, or think we may be working on soon. And this was very comforting, I have to say. We're looking in our probation system at mirroring what's being done in the criminal justice system, and developing a risk assessment, and the steps that you've talked about are the steps that we're following. So
Oh, that's
that
great.
made me feel good.
Yeah. Makes me feel good too.
But developing that risk assessment for people who are on probation to determine their likelihood of successfully completing probation or reoffending, committing new acts of discipline and coming back into the system. And so we're doing that data analysis as well, sort of looking at the data that we have now and seeing what appears to be predictive for everybody who has completed probation within the last 3 years. What are the factors that they have in common if they have returned to probation or failed probation? And we're also doing, much like they did in the criminal justice system here when they first rolled something like this out, we're looking anecdotally as well. We're not going to have a complete set of data, and assessing for our people who are our probation deputies, what do you think is predictive? What are you seeing on a daily basis? But that's sort of one piece of the population, right? Of the population, as you were talking about, who's already offended.
Yeah.
The other thing that this brings to mind is one of the strategic plan goals that we have, which talks about doing a self-assessment and identifying, sort of creating a voluntary self-assessment tool, an online tool that would allow practitioners, and maybe it's targeted for solo or small firm practitioners, to assess their knowledge in particular issues and areas, and then creating an intervention in the sort of education level of your pyramid so if the self-assessment starts with, for example, self-assessment on client trust accounting principles and requirements. I think ultimately we were talking about doing a comprehensive self-assessment, but we have to start somewhere. And we may determine based on data that that's the place to start, that's the place that has the most impact on the public. And then developing an intervention of, if you have scored X on the self-assessment, you must or you should take this e-learning course that the bar would create on client trust accounting, or something like that. And so that's one of the areas where I think we've been toying with this model in our heads without really sort of knowing that that's what we were doing or talking through the steps of it. But that might be something that we want to sort of explore further in terms of how we would take these principles and apply them in a preventative way based on the data that we have.
Yeah, I think the continuing education interventions make a lot more sense as targeted and tailored interventions than they do as generic interventions, and there is some evidence to suggest that. That makes a lot of sense to me. The other thing that you mentioned was, you're doing, by focusing on parolees, you're doing what I would call secondary prevention, right? It's not that you can't prevent additional problems. It's just that you're already dealing with select population. When you're thinking about, complaints that haven't yet happened from a population, but your entire regulated population, that's what I would call primary prevention. So primary prevention sounds great, and it has a potential to reach a much larger population, so that's attractive. The beauty of secondary prevention comes back to some of these information problems. You actually have a lot more information on your parolees than you would have. Parolees become your background population in that context, and you have a lot more information about them than you will ever get on your background population in primary prevention. So you can do a lot more. You can get some of the variables that I imagine you're dealing with are a lot richer than anything you could ever get up to the extent it's relevant to a background population for primary prevention. So I think that makes a lot of sense. And if rates of recidivism are high, then the potential for preventive action to make an impact, I think, is very substantial by focusing on a population like that.
Well, I was going to, I had the same reaction Donna did, which is this supports some of the initiatives we have underway already because the statistics we do have for California lawyers is very consistent with the notion that there's a very small number of lawyers who result in the vast majority of discipline cases overall, and that we have a high recidivism rate. So that tells us, in terms of preventative measures, we're looking at the right population, I think. The other thing that I hadn't thought about before that your presentation made me think about is this idea that problem practitioners end up moving to smaller or solo practices, and it's easy to understand why, because if they're especially problematic, no one is going to want to practice with them because they're too risky and they don't provide good service to clients. And we had talked about, in general, not just with the probation class of practitioners, but in general, trying to start identifying when people move from a firm private practice to solo practice and provide some educational outreach to them and even this and self-assessment. So I think this data supports that initiative also. So that's more in primary prevention and with obviously more in a low level of intervention like education. For example, education on trust accounts, because if you're in a law firm, you're typically not responsible for day-to-day handling of funds. But if you start a solo practice, that's suddenly a new area that you need to be aware of. But it is really concerning because you can see this being a downward spiral where people leave an environment where there's some checks on their behavior, then they're kind of ejected because they're behaving so badly, and then they have no support, but also no restraints on their behavior.
Yeah, I think that's right, and that finding we published in the New England Journal last year from the study. It was a national study of physicians, and that was sort of the most alarming finding in the study. We were looking at the trajectory, the clinical practice trajectory of people who accumulated malpractice claims over a period of time. We had, I think, a 12-year window. The main purpose of the study was to look at geographic movement because the National Practitioner Data Bank that exists for physicians, it's a mandated reporting system that all paid claim information goes to the federal government, was set up in large part to address the problem of geographic movement. A practitioner would accumulate a bad record in one state, and then because they're state creatures, would move to another state and wipe the slate clean. So the MPDB was introduced in the early 90s. I don't think there is an equivalent for legal practitioners, but it was introduced in response to that concern about geographic movement. We didn't find geographic movement among practitioners who accrued these claims, and we don't know why. It may have been that once existed, but the National Practitioner Data Bank has stemmed that problem. I should have said that anybody who credentials or gives hospital privileges to a practitioner is required to query the data bank before they offer that employment contract. So there's no mandate about what you do with the information, but you are required to query on any new practitioner. So that this information would come before any new credentialing authority. But we did find this surprising, I suppose not surprising in retrospect, but this finding about shifts in practice group size. And I think our hypothesis was exactly as you said, that these practitioners are sort of on the nose with their partners, or they may feel like their reputation is so tarnished in that practice environment that they just want a fresh start. But they're kind of the people that you would least want to have in solid practice, at least in the medical sphere. Because it's not just the peer oversight and the lack of contact, it's also that some of the infrastructure that helps patient safety is less likely to be in those solid practice settings. So I like the idea of kind of focusing on, I think there's probably a reason to focus on solid practitioners as a group because of some of these issues. But I think if you wanted to isolate a particularly risky pocket of them, it would be those movers, I think, people who move into these practice environments, particularly after a checkered history. It puts me in my mind, there's been a series of really elegant studies looking at falls among the elderly. Falls are a huge problem. The most common source of injury in the United States are falls, often among the elderly. But the period of time, the highest risk period of time for falls are in the first 3 weeks an elderly person moves into a nursing home because they're not familiar with the environment and everything is new and everything is different. And you can imagine a similar thing for people who change their practice environment into a sort of, especially to a less supported one.
And Sean, we know when people are in a sole practice versus in a group? Because you talked about grabbing stuff we actually already know.
We're trying to start collecting that data
Oh, we will?
more
Okay.
rigorously, right?
Yes, so that was one of the items that was at the January board meeting, was the board's adoption of a new rule that would require practitioners to begin reporting what we referred to as their practice sector,
Yeah.
which would be private practice and size of the firm, so solo or 200 plus or whatever the categories are that we would have. And the impetus for that was this very issue of people moving to small firms, never having seen a trust account in their life, and suddenly having the responsibility, and the notion that some amount of misconduct that happens is due to simply not knowing, not malfeasance, not being a bad actor.
Are you aware of any research that has evaluated the risk among especially solo practitioners, let's say, of having legal malpractice insurance versus not? Because it seems to me that insurers have an interest in communicating good practices to their insureds and so forth and so on, and I just wonder if there is much of a discernible differential
I
between
don't
those who do.
know much about legal liability insurance. So it's not a requirement that practitioners have liability insurance in the state?
I chuckle because I was on the malpractice insurance working group task force created by the legislature and appointed by the bar that looked at that question for a year and a half. And we were unable to come to any conclusive findings or recommendations. So the short answer to your question is no, it's not. It's not a mandatory requirement in California, and I think it's only mandatory in Oregon, Minnesota. There aren't many states.
So it's the same with medical. You know, there are a few states that don't have the requirement, but most do. But to the part of your question about the role of the insurers, this is a little bit of a puzzle for me. It took me several years to realize why I was having such a hard time getting liability insurers interested in this stuff, particularly the frequent flyer stuff. I think I figured it out. I should have known earlier. Really, two reasons. One is, in a strict economic sense, they're not actually that incentivized to implement quality improvement programs and try to mitigate risk if they can just price for the risk. So it may be that an insurer is very passive in this area because they feel like their underwriters are telling them, the balance sheet looks good, you have pretty high claims rate, but your premiums are high too, and it looks okay in the future. So they care about like unexpected risk, not risk per se. But the bigger issue in this area for liability insurers is there's a kind of collective action problem going on here, because what the liability insurers do is when the practitioners have several events, particularly several events in a short period of time, that is an outlier for their practice area, they just show them the door. They just send them on their way. And that, from a public protection point of view, it's just the worst possible outcome, because they go to a new insurer, all of the information about their prior cases and all the rich detail of this case, that's locked away forever now. There's no institutional memory for those people. So they feel like they've got a pretty good hedge against frequent flyers, and that is exit. So from a policy standpoint, it's very undesirable. But from the private insurer's point of view, it's perfectly rational.
I have a question about what I would call meritless claims in the field of medicine. We receive complaints between 15 and 20,000 complaints a year. Of those, maybe 5,000 or so will move from initial intake into an investigation phase. So there's 2/3 of the complaints, maybe more, don't even reach the level of the initial attorney who evaluates it saying, yeah, there's something there that we should look into more. And I think that, I mean, it's a big workload burden on our staff. I'm just curious how that compares to the medical profession. And in particular, I'm curious because we've been looking at surveys that we conduct of complaining witnesses where we ask about their satisfaction. They're generally pretty unsatisfied with how the state bar has treated their case. But I can't help but wonder if there isn't something on, I referenced it in my presentation, on the demand side of how we manage the expectations of people who come to us.
Yeah. So it's a great question. There's been some work in the medical space on vexatious complaining, but the thinking in this area has evolved quite a lot over the last 10 years. Jerry Hickson at Vanderbilt has been a real leader in kind of re-educating many of us about the way that we think about these issues. And his basic position is that you should never use the word meritless complaints because although we know that there are some odd people out there that get upset about odd things, meritless, you know, we understand this as lawyers, might well mean that there's just not enough evidence to move forward with the complaint. Not that nothing happened or that there was inappropriate behaviour or incompetence of some kind, but there's not enough to launch an investigation. So I think I would be careful about using that term. And I think that not proceeding to investigation is not the same as meritless in my view. And I think we can also think about those things as data points. This is sort of what the point that Jerry pushes. It may be that you know, a practitioner who has 1 or 2 meritless complaints over a 5-year period, we haven't learned much about them at all. But a practitioner who has 10 complaints, none of which can move forward because there's not sufficient evidence, but they happen to all be around a similar kind of issue, that's actually a signal there. And so I would urge you to not push all of those complaints aside when you think about this kind of work, but think about how you might use it in a judicious way to give you more information about the practitioners you're interested in.
What about communication with people?
Yeah, I think it's very difficult. There is a literature around this. So, for example, there's a bunch of studies in the Law and Society area trying to understand whether people's satisfaction with how the legal system treats their cases is entirely bound up in outcomes. So, you know, like what does the concordance look like? If you have a favourable outcome or an outcome that concords with what you wanted, is your satisfaction always high? And if you get an unfavourable outcome, is your satisfaction always low? It turns out that's not the case. It is possible for people to feel good about the system and the way that their case was handled, notwithstanding the fact they didn't get what they were after. And the other way around too. You seemed to get what the claim was about, but you still felt like you were treated in a very poor way. I'm not an expert on how to manage expectations and how, you know, what the hallmarks of a kind of well-handled case. I mean, I could make guesses as well as any of you. You know, regular communication, clarity about the limitations of the process up front. I mean, I think all of these things are what case managers in other areas like workers' comp have kind of evolved to try to do as part of their case management techniques.
I think that the question arose from a conversation that I had with a colleague of mine who was actually referencing what he had read about the challenge of not prescribing as many antibiotics in the health field and the difficulty of patients really wanting antibiotics, physicians being told there's a broader problem of over-prescribing of antibiotics, and certain institutions simply putting communication up on the walls and making it very clear, we do not prescribe antibiotics for these things, which made it easier for the physician to have that conversation with the client, with the patient about, you know, this is what we can do, this is what we can't do. And your point about calling them meritless, well taken, but if we could get clear about what is it that you can really expect from the state bar's regulatory body, and what are the alternatives that may be available to the resolution of your problem.
Yeah.
This is the kind of thing that I've begun to try to think about in terms of where we might go with our communication with clients, with complaining witnesses in particular.
No, I think that's something that other adjudicatory systems have done. So, you know, the idea is you need to first establish what people want from the process. You know, and that in like the medical malpractice area, which I know well, there is a range of sort of settled options that people tend to think about. You know, a very common one is damages, obviously, and that's what the system's there to provide. But then there are others like, you know, I want this to never happen to another patient again. I want the hospital to implement a risk management process. I want the physician who was responsible for this to sit with me and go through what happened, which never happened in the hospital because risk management whisked him away. So there are a set of things that, you know, it's important to clarify what people want. And then on that list, there's always going to be a bunch of things that the particular institution that you are dealing with just can't provide. So, for example, damages for your you know, misconduct, disciplinary matters. I mean, it would be really valuable, and probably you already do this, to explain up front. We do not offer damages. You know, we're not a body that provides damages. That would require a negligence claim against the practitioner you're concerned about. So, I think all of that, again, is in the common sense category and augurs well for sort of you know, consumer satisfaction.
I held off lunch because we were having such a good conversation and I didn't want it to interrupt, but I've actually asked for them to release the food.
Oh.
So it should be arriving at any moment.
Bringing it in here.
It was going to come at about 11:30 and I said, no, I don't want to interrupt this because I thought we had a good conversation going. It should be arriving in just a
Good,
moment.
so, did you want to pick up the lunch and have a working lunch, or did you want to take a break? And what is your timeline for the rest of the?
So Professor Studdett's going to need to leave at like 12:30. So I suggest the lunch should be arriving at any moment. Let's take a break, grab some lunch, and then let's. I mean, I'd like to thank Professor Studdett very much for taking the time and sharing this information. And if it's okay with you, I'd like to make the PowerPoint presentation available to the members just so that they can review it for those members who weren't able to attend today. And then I think a follow-up discussion among ourselves about what we, you know, what our thinking is, what we learned from today's presentation, and how this might inform the report that we write.
Just to follow up on the last point, I think that some of the discussions you just talked about sharing more around what people's expectations could be, should be, can only be, would be important. We started to talk about in the tax collection world, an exciting world, I promise you. But like, for example, people will say, oh, you know, I got this penalty. Well, in San Francisco, most of our taxes are paid by businesses. So a conversation with a business owner or representative or whatever is far different from with an individual taxpayer. But one thing that is paid by a lot of individual taxpayers is property taxes. And so we'll get a lot of individuals that will say, like, wait, I got this late penalty, you know, I don't think I deserve it, and they want to have a conversation, and they want to get it removed. And what we do have a form, obviously, that they can go to, but what we've talked about a lot, to the point you guys, I think, are making, is we could be clearer up front about here's the things that might count as a way to get an exemption from the late penalty, and there's like one or two. 99.9% of people who get it don't have that issue, and therefore they have there's no way to waive the late penalty. So we get far more of the people, though, that don't have it, who still apply and hope they'll get it. And I think that's very similar to one of these things where you're like, we should just tell you up front, you know, unless you got this or this going on, just pay it.
Yeah, save time.
Save time. Don't let those unreasonable expectations survive too long, kind of a thing. Don't let them think, oh, I entered the process, so I've got a chance, when maybe they really don't.
And to that point, one of the organizational changes that was introduced shortly after Leah and Elizabeth took over the leadership of the organization was we went from having complaint analysts. It was a thing in OCTC where complaints from the public by way of phone were handled by a complaint analyst who we were concerned at the time was being overly narrow in their interpretations. And we were concerned that they were discouraging people from filing complaints when we wanted that. At the time the decision was made, we really want to open the spigot wide. We want everything. We want the attorney who's the lead attorney to make that determination as to whether or not it has merit, for lack of a better word. So I can't help, as we've begun like looking at these different issues, I couldn't help but start to wonder, is there something in between some complaint analyst who's not legally trained, who's making maybe too narrow a determination as to whether the person should file a complaint, and the open the spigot wide? Is there something in between where we do a better job of triaging at the point of intake and have trained people who can say, you know, your complaint isn't likely to succeed on these grounds or in this forum, but there are issues there that might be better resolved in a different forum.
And that's also an intervention point, actually. So one of the big pushes in the medico-legal world in the last 10 years has been the so-called open disclosure movement. And this is the idea that a lot of claims, malpractice claims in particular, are generated from essentially an information gathering motivation. They don't know what happened and people are frustrated by that. They didn't get that conversation with the hospital or the physician. So, you know, the idea was that this might be a risk management move, actually, to be more forthright about these conversations and have a structured process for doing that within hospitals. So it's become a national accreditation standard in the last 10 years.
What is the name of this?
Open disclosure.
Open disclosure.
Yeah, so you could think about at that initial intake point, one possible intervention would be the regulator contacts the practitioner and encourages the practitioner to have a candid conversation with the client, past or current, about a particular issue. And you know, the theory would be that lowers the risk that particular event will blossom into a fully fledged complaint, especially when you don't think it's, when the initial read is that it's not a deep substantive problem with the practitioner.
Could part of the answer to Dag's question lie in data analytics? I mean, if we have data that suggests certain types of complaints end up being investigated and charged, whereas others don't, instead of a person making that call, could it be an AI algorithm? Is that?
I think
If we're allowed to.
I think that makes sense to me.
I figured it might.
I mean, I think about like, again, malpractice is the area I know best. You know, Walk-Up Melodia probably gets the most, you know, plaintiff cases in the city. They have one partner that does nothing else but screen cases all day. And they have it's not formalized in an algorithm.
What kind of cases did you mention?
Prospective malpractice cases, plaintiff
Yeah,
side.
but you mentioned there's one person who does a particular type of net now.
No, so there's one partner that whose job it is to screen all incoming cases to the
Oh, the
firm.
intake.
So they get about 1,800. Actually, it's probably not that different to you guys. They get about 1,800 queries a year.
18,000 is more like what we get.
Oh, 18,000. Okay, so
Complaints.
order of magnitude.
Yeah.
But you know, they probably take. I forget. I have one of their attorneys comes to my class every year and talks. I think they take you know, maybe 30 of those cases a year. So they've got to go from 1,500 to 30. There's a partner who's basically sort of listening to the story. They're not pulling medical records at this point either, but they're, so for example, one, you know, deal breaker is, you know, that they do an initial assessment of prospective damages, and the $250,000 cap under micro is just a deal killer. If there's not going to be sufficient economic losses associated with the case, it's an elderly patient who doesn't work, and the injury is not very, very severe, then that's just going to be a straight rule out. But they have, you know, this. I mean, the analogy is they have a kind of a list. It's not algorithmic in a formal sense. It's more like perhaps the one you were talking about. But they've developed that over the years, and they have extremely strong incentives to get this right. Because if they're working a case that's a loser, that's coming out of their pockets. So they care a lot about this, enough to devote one partner full time to doing this kind of work.
So we do have a contract with an organization that is looking at if they can take the complaints that come in the door and through AI, through machine learning, determine if these are complaints that should be forwarded or not. The work has been a little bit slower than we anticipated, and so one of the things that they're doing to facilitate their being able to see if they can do this is they're building a TurboTax-like process for complaints. They're piloting this because that way they may get in the information that will help them see if there is the ability to make decisions about complaints being forwarded or not. Obviously, we would spend quite a lot of time doing a double blind, if you will, and sort of seeing how accurate it is. But it is something that we're looking at when we have 18,000 complaints coming in the door, having some ability to see if there are ways through technology to make those decisions more quickly and less resource intensive.
That's great. That sounds amazing.
Yes, of course. I can have two. If you want, you can have two. Okay.
So my suggestion is this: if you have to leave around 12:30, we have some lunch back there, so please have a lunch.
I will.
And why don't we all go ahead and get our lunches and then come back and
I'll take it in the box.
continue start with any questions we need answered from Professor
Right.
Steiner, and then we can move into our own internal discussion. We ask.
Okay. Yes.
Thank you for your time.
Oh, sure.
Yeah.
It's a pleasure.
It just sort of
Okay, we're back on in session of the 2020 Government Public Interest Task Force, and we have all of the members who were here for the original roll call this morning, along with Donna Herskowitz, the interim executive director of the bar. Okay?
So what I have for to wrap up today's meeting is some questions that I have put together prior to the presentation. Some of which I think we'll look through them and we'll see right away that we either know that or we got that information during the presentation, or maybe it's not that useful. But others of which are intended to maybe focus on components of the attorney discipline system, and then another which is sort of gets back to this question about what we're hoping to include in the report itself when we get to May 15th. So let me just start with these. So the question of what's the same and what's different, I think, as a general question, it might be easy to dismiss. Like, what does it matter? What's the same? What's different in terms of how medicine works as opposed to how attorney regulation works? But I think a lot of times it's when you get into the details that you find that there's some value. What works in medicine that might be borrowed from the legal profession, my takeaway from today, and I was already seeing this a bit in the literature that he had pointed me to, is that it's not like people regulating the medical field are light years ahead of us. It's all pretty nascent in the medical field as well. So I think, I don't know that we, Jose, I think you asked a question about like, well, what does that look like? How are those evaluations going? Haven't really done them yet. What are the interventions? Well, the interventions, they're all kind of like being built out. There's a lot of, I think, exploration still going on in the medical field, and I think we're not that far behind, and it's not like we have like there's not like the model out there, like that's what's working, that's what people know, already have done, and that's the thing that we need to do. I don't think that's out there. There are some big concepts that I think are useful. That I thought that the pyramid was a useful concept. The ideas about data and what we might do with data.
Sure.
The question about institutional mechanisms, this was my inelegant way of trying to ask broadly about this question of adversariality as the model of attorney discipline, and whether or not there might be some form of alternative dispute resolution or some form of triage that says, you know what, these cases might be amenable to a solution that's less adversarial and that provides support or resources to a complaining witness, rather than like simply opening the spigot wide and saying, you got a complaint, we're sending it to OCTC to the read attorney. And I think that what I think is potentially most useful about this idea is that it's one of those few areas where there seems to be a win. It could potentially be a win-win in that it would not only diminish the workload of OCTC if we were able to divert some of those cases, but it could conceivably increase the satisfaction of complaining witnesses because they're getting their needs have been identified up front, and in some cases found not to be the need to file a complaint that's ultimately going to get dismissed. Rather, their need was to
Have further information or reassurance or something.
Yeah, sometimes just to be heard.
Just to be heard.
They just wanted somebody higher up than their attorney to listen to what it is they have to say.
How we implement that, I don't know, but I think that's a very useful idea. I think it's a very,
Is it possible we can do
Potentially.
some sort of, mediation, that there's a step of mediation for some of those ones? Did you say that they'll have to go all the way to the OCTC, that have to go to trial?
I don't know. We have the mandatory fee arbitration is the one area where there is there's a built-out mechanism for dealing with fee disputes. I don't know how well that works, or whether that might be a model that could be applied to other types of complaints that come into the system.
Yeah, well, my reactions first, I had this thought earlier, I think we should have OCTC here to, maybe Steve and Melanie at the next meeting. In the interim, you could talk to them, but these are some interesting ideas. There is something called the Alternative Discipline Program, unless it's been abolished, which is sort of a diversion type program, but I've never really studied it, so I actually don't know the parameters around that. I do know that OCTC does engage in some informal intervention in at least one area, and I bet there's others, which is fines. So it's a very common complaint clients have about lawyers is they have fired their lawyer, or the lawyer has fired them, and they can't get their client file. And so I know for a fact that OCTC will call the lawyer and just try to work this out. I mean, it's also can be a disciplinary issue, but they just call them and say, get the file to this person. So they solve the immediate problem. And there may be other areas where they already do that, or they could, I suppose you could consider doing that. But it's definitely a different paradigm to say, are there sort of some types of things that might be amenable to some resolution. I mean, it would be really. So it's worth thinking about. I guess we have to think about what that would look like,
Right.
and how it would operate. The different skill set.
who would
type of
staff
people
it?
who would do that.
Would
Yeah.
it be statewide, or would it be one area? I mean, then how do you control quality of outcomes? I mean, there's just a lot of different kinds of questions, but it's not a bad idea to investigate to me.
The one, actually, I do have a couple other ideas. So one is, so going back to the professor's presentation, the interventions. So I know we're looking at interventions for people on probation. But one of the things that caught my attention when he was discussing, and I didn't ask him more questions about this, and we might follow up, is he mentioned that in the medical field there are some, sounds like there are companies or firms that provide intervention services to physicians. So it's kind of a mentoring type, it's a one-on-one mentoring type of thing, which I think could be extremely beneficial to certain people. And that could be That might be something we should look into, because OCTC has the power to do alternative resolutions already. They can do something that's not very well known, which is called an agreement in lieu of discipline. It gives them a lot of flexibility. So it's an agreement with the respondent. As the title suggests, it's not discipline. The respondent has to admit to a violation in this agreement, and if the responding attorney engages in misconduct in the future, then the charges to which the lawyers agree can be brought in state bar court in addition to whatever else that person has done. So it gives them a real incentive to comply with the terms of the agreement. And you could see adding consideration of maybe some other requirements in ALDs that would be a form of intervention and would enhance or reduce recidivism, basically, for that population. I think we saw statistics that there's a pretty low recidivism rate for ALD cases already. So maybe we could decide it's not worth it. So those are some ideas, yeah.
So a couple things that occurred to me. One, in relation to that last point, I think we would need some mechanism to, well, what I'm struggling with is we want to balance the resolution for the particular complainant and the overall public protection need. And so I think there'd need to be some sort of mechanism for us to identify, again, sort of this is the type of case that's not going to lead to recidivistic behavior, so we can address it as to this particular complainant, and we don't have to worry about the bigger issue. The public at large is not at risk from this attorney. And so whether it's and I think the concept of the mentors is actually something that the probation folks are thinking of as well. But so it's a concept of a mentor. It's one of the things that we had talked about a couple of years ago that we haven't yet had the opportunity to explore in the mandatory fear world is, instead of arbitration, looking at online dispute resolution and more of a mediation kind of approach. And that could be, again, if it's something that really is, we're not worried about the recidivistic behavior, then maybe if we invested in the tool, and there are various companies that create these tools, we invested in the tool and we're able to hook the complainant and the attorney up and some of an online dispute resolution approach, that might be a satisfactory result for both the complaining witness and the respondent.
Oh, another idea, those are all good thoughts. Another idea to add is OCTC can and does close some files with what they call a warning or directional letter, and they may consider those two terms different for whatever reason. Doesn't matter for my purpose. But I have seen several of them, and I think it's a form where sometimes the direction is nothing more than to read the rules of professional conduct, which is not especially useful in my view. And so you could think about having some attention given to what are common complaints against lawyers that they decide not to proceed for whatever reason, and what are some more focused resources that can be offered. This is totally voluntary on the lawyer's part, but if it's a trust fund issue, and they may do this already, but it should be directed to trust fund training, for example. But there may be other situations where that could be useful in avoiding a repeat of the same problem.
And I think that could ultimately be more successful when we determine what's the preventative education that, again, one of the strategic plan objectives is to develop a comprehensive preventative education curriculum. And when we determine sort of what that should be based on the percentage of complaints, right? Most of our complaints come in at X category, so we should have education on that. And if we have, through our e-learning platform, have education on client trust accounting, on whatever sort of are the most common errors and types of misconduct, then we can direct them, because even if you direct somebody to the rules or a particular case, that may not be an effective method for them to learn it. But if you direct them to an e-learning module where they'll even get MCLE credit for it, so there's benefit to them to do it, then that might also be helpful. So ultimately, we need to build out what that curriculum is and decide what are the things that we are going to develop e-learning courses.
Do the complaints cluster in certain areas? So, for example, failure to communicate, is that something more than mishandling client trust funds? Because those are two very different types of problems, right? And I would imagine that for whatever tools we have to either do preventative or corrective instruction or requirements, they're going to look different as well. And what are we doing now on that? Do we do anything on communicating with clients?
I don't have the answer to that off the top of my head. I mean, right. I think it depends on the individual case. The other common thing in the so we've got the resource letters and we've got the warning letters and we have I think what they call comms letters, where the complaint is my lawyer hasn't communicated with me. I've tried to reach out, my lawyer hasn't gotten back to me, I don't know what's going on in my case, and that's also one of those situations, like the please return my file situation that Sean described, where ODPC would reach out without necessarily opening a case, they would send a letter to the lawyer and say, within 10 days, call the client. And they tell the client, we've told the attorney to call you, and if they don't call you within that period of time, then come back to us and we'll open the case on it. So we do that kind of thing if it really is sort of just failure to communicate. I know historically we have identified like the 10 most populous types of complaints that we get, and I don't know if we've done that recently, but certainly they do cluster, and there are complaints in various areas, and failure to inform, probably failure to communicate or inform of significant developments is one fairly common one, and trust account related violations is something else that may be fairly common. So there are ways to see what those common complaints are and develop interventions that relate to each of those.
We have something of a data challenge with this, just in that there are allegation types. These aren't all of them. These are the ones that I put up on this slide because they were ones that had statistical significance in the model when we were looking at the discipline, the factors that contributed to the likelihood of being put on probation or disbarred. So you get something like, say, professional employment, and this is a big category in the legacy data, and all of the data that was kind of how it was categorized as professional employment. Well, under that, it looks like there are about 20 different components of that. Could be solicitation, and they're each keyed to either a rule, state bar rule, or to a business and professions code section related to legal advertising and symbols, legal advertising impersonation, advertising communication regarding guarantee, advertising communication regarding testimonial. Very detailed sorts of things, but that might make it a little challenging to pin that down. And then a further issue right now with the data is that now that we've transitioned to Odyssey, those categories aren't built up out of Odyssey. Odyssey takes it at the discrete level of individual, the things that I was just reading, but the system hasn't yet been set up to then aggregate that all back into, the overarching category is professional employment. So we got some data work to be done on that, and
It's really soliciting employment. Soliciting employment. That's those general categories of solicitation and marketing.
But those were under the rubric of professional employment. Is
That-
what I hear
that's-
you saying, like there's
yeah,
a big
No, I
list.
know. It's a strange nomenclature.
I agree. Yeah, because professional employment on that list doesn't mean a lot to me. As you started to read some of the
Yeah.
things, I realized what it relates to.
it didn't mean anything to me when I saw it.
Yeah.
I thought, professional, what does that mean? And then I saw then I looked at the underlying codes.
Yeah. Can I make a comment about Odyssey? And neither Melanie nor Steve is here, but they've heard this from me in the context of RAD. Let me be careful with my words. the bar is spending and has spent a lot of money on that suite of software, and it strikes me as unfathomable that there's not some mechanism or tool in our professional services contract with that vendor to direct the kind of tweaks that we need from a system like that. I have public agency clients who enter into, similar contracts with software vendors all the time, and to the best of my ability, I make sure that there's something written into that scope of services and into the terms of that contract that allow the purchaser to sort of demand the professional level that you're paying for. And I don't know if I haven't seen I don't know what the story is, but it's frustrating as a member of the Board of Trustees and as a lawyer to keep hearing that we've had these problems with Odyssey, and I don't hear of a way that we're addressing them. That's all I'll say.
I would argue with you.
And just for reminder's sake, how much is that product costing the bar?
The number that I have at the top of my head is the 1.7 million that we're going forward with now for enhancements and fixes. I don't recall the amount that was spent to date.
But in the seven figures.
I think it was probably about maybe 2.5
For the original or for the?
for the original.
I'm not a litigious guy. I'll just say that.
That's another issue.
So I think maybe more generally what I'm hearing, though, in terms of some of these suggestions has to do really with clarifying that looking to see what interventions are currently being done and ensuring that the interventions match and are aligned with the conduct, so that they're perhaps tailored as narrowly as or as appropriately as possible. Obviously, not sending somebody who is failing to communicate to client trust accounting school. I mean, that would, so I mean, I think that there's, and that's partly an empirical question. I don't know what these look like. I would be curious to look at what the range of different types of, and this could, not only an empirical question, but something good for our work plan, or, what, as we start developing a list of things that we're going to do, understanding better what the range of different types of communications are, what the range of different directions or warnings are, and how the decision is made to direct somebody to do this rather than that, and based on what the case is. So trying to get a better sense of what those decision rules look like, and then what the range of options are is related to those decisions. We focus a lot on OCTC, understandably so. It's over half of, I think, State Bar employees are OCTC. Easily over half of the State Bar's budget is devoted to OCTC. But I think Melanie and Steve both pointed out to me when we were discussing the presentation by Professor Robertson, when he was talking about the possibility of finding some mechanism for helping unrepresented attorneys. Both Melanie and Steve kind of looked at me a little slightly helpless shrug, is that really the prosecuting office's role? And I think it's a fair question on their part. I think traditionally a self-help center might be located, say, within a court. That's a more typical location of that type of service in the court system. So
maybe we're asking OCTC to do too much. Maybe there are other, like you say, there are other alternatives that we could construct to relieve some of those complaints or preclude some of those complaints by earlier action.
Right. Even the previous conversation about agreements in lieu of discipline as what does that look like, and what are the conditions contained within it, and how do those either support, prevention of misconduct in the future, or arranging to ensure that the client gets what he or she needs. The notion of problem solving, fill in the blank, problem solving justice. I've heard it mostly in the context of problem solving courts, and it sort of grows out of the drug court movement. The alternative, the ADP, is it called, alternative dispute, is primarily geared toward alcohol and mental health issues, and has been sort of an offshoot of the LAP, where the lawyer assistance program cases come into the discipline system.
That's right.
And an argument is made by a client in OCT as he accepts that the misconduct had a direct nexus with alcohol substance abuse issue, then they can get into the ADP. Our general sense is that it's pretty underutilized. I think that the judges, when we were exploring this issue some years back, there was a sense among the judges that it was a reduction in this. It offered the potential for a reduction in the severity of the discipline, and as such exposed the judges to some risk with regard to bad publicity. That if they allowed there was apparently some notorious case, possibly in the Central Valley, related to an attorney who had been put onto the ADP and maybe given a little bit of a pass, and then went on to commit some egregious misconduct that they made some names. So, but that said, I think that the notion of problem-solving interventions, or I don't know where the point is, and maybe it's at multiple points. Maybe at the point of intake, to identify more clearly what are the issues, and make sure that only those cases that really are bound for the attorney discipline system go to the attorney discipline system, and finding if there isn't some subset of cases that have some alternative mechanism for resolution.
Well, the question there, though, is, as your bullet point says, is okay, who's in charge of that at the bar? If it's not going to be OCTC.
Yeah.
Is it? I don't know.
Yeah,
Not
who's the
admissions.
oversight? Yeah, who does the oversight on something that's
Right.
outside of my OCTC? They probably shouldn't do that.
Yeah. And I think Steve and Melanie's point about the shrug relates to both what you said, Alan, in terms of that there's a big demand on that side of our shop, but also with respect to, because I think the issue came up came up with, hey, you need to go get represented, right? Respondents who are represented fare much better in the discipline system, and I think they felt like, just sort of philosophically, it was an improper step for them to be taking when they're supposed to be taking adversarial or prosecutorial function on one side, and then yet we're going to tell our respondents how to go defend themselves. It's just that was my impression of the reason for the shrug on their part.
I'm almost thinking in terms of maybe we should have some kind of first step. I mean, complaints come in or that has broader mandate than prosecution, and maybe the OCTC is the end of the line for some of those complaints, but instead of just everything goes into the OCTC and somebody there decides whether it has merit or not, maybe there's a step back or a preliminary step that we could go through with different people than prosecutors who could fashion or discover other alternative ways of handling some of these complaints. And then if there's a legitimate problem and it really does need prosecution, then it goes to OCTC. But kind of getting the impression that we're asking OCTC to do some of this preliminary stuff.
Is that because the intake part of our business is in OCTC?
Yeah, well, and let's talk about what they do in intake in OCTC. So the complaint comes in and they review it and essentially say, assuming all facts in this
Right.
complaint are true, does the complaint state disciplinable conduct? Right? That's essentially
Which is a
the analysis.
prosecutorial screen.
It is. I mean, if they're looking for, is there a possibly colorable claim here? Okay.
Right.
But for those, and what I wouldn't want to do, right? So that's depending on the number of complaints that come in, that's a lengthy process for them to review. I mean, the goal is that most of the cases move out of intake in 20 days. But they've gotten a huge number of complaints in recently, and it's taken a lot of time to get back up to moving them quickly. So I'd be cautious about creating sort of a preliminary screen that precedes that screen. And so maybe what it is when the read attorney in OCTC is looking at the complaint to say, they've got 3 buckets. Is it a colorable claim? Yes, that goes into the bucket that's going to go to investigation and see now if the facts bear out. Maybe they're putting it in the other buckets of, this seems like something that would be easily resolvable with some other kind of dispute resolution. This feels like someone who really needs to have a real conversation with somebody and needs to have their issue heard. It's just not something that we would ever discipline somebody for, whatever those buckets are. And there would, I think, have to be training, as you say. These are prosecutors, right? And so there would have to be training on looking for which bucket it goes in. But that,
Yeah, I'm almost thinking of and I'm not, I think this is real blue sky, which is what we're supposed to be doing here, but I'm almost thinking if there are X percentage of complaints that come in that could be resolved by some of the things we've talked about. Somebody calling up and saying, would you please call this person? Calling up and saying, please transfer the files, you're under a legal obligation to do so. Or let's have some kind of variation of attorney-client mediation to see if we can't work this out. And then if cases, and it might be 90% of the cases or it might be 50% of the cases, none of that's going to work anyway, it's a real prosecutorial complaint, then it goes to OCTC. But let's not burden OCTC with all of that preliminary screening, which would be something in the future we would be doing more of then than we are now. Where would we have the resources? Who would do it? Would the legislature believe that we were trying to, step beyond our role as a governmental regulatory agency? There are all sorts of issues that would come up that you would have to get through, but that was my concept.
Well, I think potentially within that, those cases that have been filed as complaints are reviewed by OCTC, by the reading attorneys, as Donna described. I don't know what volume of cases are generated, though, with initially a phone call. And the phone calls have been diverted out of OCTC and are handled by our call center. And this is what I was describing about we opened the spigot wide. We stopped attempting to screen at the phone call.
But I thought you said earlier that like 2/3 of the complaints that we get are not sent on to investigation.
Yes.
So out of that 2/3, should we be concerned about those 2/3 of the cases, of the complaints that we receive, that might be able to be handled in a way that doesn't result in discipline, but satisfies the public, protects the public in the sense of solves some of the problems? Okay. Again, that may not be within our narrow mandate, but maybe we should expand the mandate.
Nope, I like
maybe
that.
we shouldn't.
Yeah.
I don't know.
Yeah, maybe the report could include a price tag in addition to some recommendations.
And stakeholder acceptance and all sorts of stuff.
Yeah.
Is that it? Is that your last slide?
I think it might be.
Oh.
Oh
no.
Is that all there is?
I had
The 3 Ps again. Here we go.
yeah, well, that's true. And 2 Ds. So, just trying to clarify for myself, because I have a feeling I'm going to do some writing, what's going to be in the report. So, I think and what we're going to continue to do among ourselves. I think we're going to continue to do some conceptual clarification about what are these different things that we're talking about. What is preventative or proactive, predictive regulation, data-driven regulation, and what are the tools? So we will continue to learn as much as we can and clarify concepts about what can be done in the regulation of the law. I found the literature that Professor Stutter pointed me to like pretty dense, but also that I don't think that there's like some answer out there. I found it in this law review article or in this New England Journal of Medicine article. It's not out there. They're still figuring it out as well. So I think, and maybe that's what the literature review will ultimately say, is that we're figuring it out too, and that puts us in good company.
Or at least would be up to speed with wherever anybody else is.
So, Dag, I have a question. Oh, sorry. Question and a comment. So, what's the subject of the next speaker in April?
So the next speaker in
March,
April,
whatever it is.
so
No, it's
the
March.
March.
March 5, Los Angeles. So, and New York. I believe we have a New York address
That's right,
along
the
with the Los Angeles.
That's correct.
So whoever wants to attend in New York, I'm going to be sending out an address on the agenda.
You calling in from New York?
I am.
Nice.
I might just go out to join them.
I think we all
That's
should.
my dad.
You're welcome. Anyone's
And
welcome
since
to
we have an
join.
unlimited budget, let's go.
So the goal was to do cross-discipline comparison, which was today, and cross-national comparison. So the methods class that you take, like hold other things constant, but look at one different dimension. So in this case, the different dimension that we looked at was the different profession. Next time it'll be the same profession, but what we're going to look at that's different is the practice setting. It's Australia. It's the research article that was written for the Journal of Empirical Legal Studies was done down under.
Yeah. So I don't know what others think, but my reaction is, I think we already have a pretty solid list of practical things to look at and to think about whether they could be implemented and how. And I wonder if, it seems like our attention could be most focused on that. I mean, the literature review is helpful if it helps you identify other practical measures, but I think in terms of, action items, that maybe we should maybe move our focus to that.
To fleshing out some of the ideas that we've been talking about?
Yeah.
Or even review a draft, an early draft.
I mean, my reaction to this is, I think this is a very worthwhile area to understand as fully as we can and to stay abreast of what's going on and to be thinking and conceptualizing what we might be interested in doing. In terms of actually taking concrete steps towards doing something, I'm not sure that we're there yet. The data that we've gotten is very preliminary, as he said, nascent. Maybe you used the word nascent, somebody used the word nascent, and that's the way it struck me. I mean, there's nothing I would go to the legislature or the court and say, we think based on this, we should do X, Y, or Z. But I think we ought to, to me, we could almost write the report today and say, this is very interesting. We're going to stay on top of it as AI, develops and so forth. We want to see what the practical applications might be. I don't know. I mean, maybe that's too soft, but that's kind of where I see this.
How
I
specific,
don't think we're ready to do anything yet.
I tend to agree with you. How specific was the charge that we were given? Was it the legislative function? Was it from the court? Because we have a deadline of May 15th. Came from whom and
60, 61, is it?
Okay.
This actually
Or
includes
60,
in it,
00,
the part that's not included here actually says May 15. Every 3 years, so 20.
Well, so the charge includes its recommendations for enhancing the protection of the public and ensuring that.
It's pretty broad.
It's pretty broad. So it's not necessarily a statutory change. It could just be a change in our operations.
Right.
So, for example, these warning letters,
Mhm.
just taking another look at, can they be made more
Right.
tailored or more useful?
And maybe what we should consider between now and our next meeting are what are steps that we could consider taking. I'm slightly changing my view, but I mean like that, like letters, et cetera, et cetera, et cetera.
Well, I think Dag used the phrase the low-hanging fruit earlier, right?
Yeah.
Or maybe it was you when we were talking, juxtaposing the triple LTs not against, but with adults. Well, those are two very different things, and
Right.
you know, this thing about the advice to respondents to, you know, or not the advice, the information to them that represented respondents do much better in the discipline system than non-represented. That's a fact. We're just telling you that fact. That's something that, you know, could also very easily just be. We could start that tomorrow if the direction came from Donna, theoretically. I don't know. Right. So those sorts of things.
Yeah. Yeah, I mean, it doesn't quite write itself, but I mean, they're you know, one could,
That's why we had Dag.
one could bring
Exactly.
structure to that. Yeah.
Yeah, I think by the end of next meeting, we should have some pretty good focus on being able to write that thing and then have a meeting in April and review the draft.
So, John, were you suggesting that we not bring the professor in on March 5?
Oh, no, not
No,
at
I
all.
think we should.
Okay.
I'm just saying, you had, I think on your sort of to-do list you had on the slides, was literature review and so on, and I think that's useful. It could be useful to the extent it leads us to more ideas to consider, but we have a pretty good suite of ideas to consider and study now. And the outcome of our report may be, on some of them, nothing more than this is worth looking at. Some of them that are more simple, like the warning letters or whatever, we could maybe get some feedback from OCTC now and some thought about what might be done.
And we might want to categorize these interventions by interventions with the attorney and interventions with the complaining witness, right? So if you're talking about some of the ways, Dag, that we might communicate expectations better with the complaining witnesses, or think about sort of funneling their complaints to another bucket because that's the more appropriate solution for them and will give them greater satisfaction. Right? And some of that is going to be ideal because we don't have the resources, but if we can sort of set up this framework for both sides.
Yeah, I mean, I think this report might just be an opening to start getting people's attention on the fact that this is out there and may come to fruition someday. And I think there are kind of two buckets of the public. You know, we need to frame this in public protection language, and dealing with recidivism and identifying people who might be prone to recidivism. Those are things we can look at. Those are certainly public protection directly. And then there's this subsidiary or secondary public protection of if we can prevent a lot of these complaints from having to go through OCTC, we can conserve our resources for those cases that really need it and thereby reduce our backlog and
We absolutely need to think about public protection in terms of caseload and how much OCTC can really do and what they could do better and more timely if the things that really don't fall in their bailiwick are resolved elsewhere or are resolved in such a way that they're not getting 6 follow-up calls from a complaining witness who got a letter that was confusing and didn't help them understand the problem, and right, so that is a public protection aspect for them being able to work the cases that really they need to work as a prosecutorial entity.
And isn't it the case that we already have quite a bit of stuff going on, underway that is directly responsive to answering that question?
Yeah.
Would it be to our organizational benefit, but also just to people that we're regulating, to just point those things out? Like, hey, you know, we're not starting from ground zero.
Yeah, no,
here.
I think that's.
You know, we're already 30 yards down the football field.
And also going back to Sean's suggestion, let's think about whether it would be helpful to have Melanie and or Steve here for that next meeting, so we could kick around some of this conceptual idea of what OCTC should be doing most effectively and what might potentially be lifted from
And
there.
they may have some, I mean, they did like this, but maybe once they're talking to us and we're sort of in that discussion, they may have some suggestions as to some other
Some
things that
things
could
be
be
done
done.
on it.
Yeah, it could be done on the front end. So
Yeah,
that
I
they
think-
didn't have to do that.
I think they would absolutely relish the opportunity to participate in that.
And a lot of this are things that they could just implement
Yeah.
directly as part
Or
of their.
they could tell us, funny you should say that. we did that, we started that yesterday.
Right,
Right.
Yeah.
we're already doing X,
Yeah.
Y, or Z, or already working on it.
And, just to flesh out my thinking, so I think we have a continuum of things. So we have some low-hanging fruit, some things that we might dig into a little bit more, talk to OCTC about, flesh out those, like warning letters is perhaps the easiest one that comes to mind. Then at the other end of the spectrum of this list is things like, well, using AI to review incoming complaints. That's been on the list for a long time, and people are looking at that and they're working on that. So it's not something we would directly dive into. And same thing with more elaborate types of interventions, like this mentoring, hands-on sort of models. Not something we can get our hands around in a meaningful way. It's just something to list for consideration. And of course, we already have the ongoing project of looking at the probation process. So that's just, I think, to bring this around, some of that will just be saying, these are ideas we've come up with. We already have initiatives underway in this area. Here's something else that group might consider if they haven't already,
And
that sort of thing. And then we have sort of a bullet point list of possible actions.
And to build on your thinking, it wouldn't hurt in our report to say that we looked at this and we've already initiated X, Y, and Z.
Yeah, it's like the probation work they're
Yeah.
doing, and the lawyers that are going from a firm that are going solo now or going to a small firm, encouraging them to take these new classes on, trust fund accounts and all of that kind of thing. So to help them from coming into the system, that they'll learn about how to do that because they come from a firm where they didn't have to do it.
We need OCTC here to.
I mean, I think, like I said, I think we already have some things we can put on there. Okay, these are some of the things we've identified. These are some of the things we're already doing. These are some of our action items already in the pipe.
I think one of the things I would say that's important about that is, right, we were essentially identifying sort of what's the important trend or direction in regulation, and it is this risk-based regulation, right? Preventative and DAG's other P's, and what we're sort of concluding is that looking at this, yeah, these are really good ideas, and hey, wait, we're already doing some of this, as opposed to this group saying, hey, let's write a report that talks about stuff that we're doing. That's not sort of how this developed. I think we sort of ended at a place where we said, this is what we should be looking at, and hey, we're already doing some of this, and we can further the work that we're doing with the research and thinking that we're hearing about now, and it supports what we're doing, but it's a very different report and a very different conversation than if we started with what we're doing. Sort of tried to reach back and circle back to it.
All right. So make it happen.
Make it so.
Make it so. All right.
Would it make sense to see a draft in March and not just in April? So we're not just looking at a draft once? That must be an exciting idea to you.
Or
Dag looks
if not a draft, maybe some outline.
Even an outline,
whatever,
or
something.
like
Yeah,
that. So
I
we
think
have
outline.
something that kind of
Or
captures what we talked
partial
about
draft
today.
or something like that.
Yeah.
Full outline and partial draft
Yeah,
or something.
sure.
If we're gonna write something by committee.
You have experience with how long it takes for committees to write?
I've just heard stories.
Voice of experience.
I've just heard stories.
All right, we'll, unless anybody has any other questions or comments, we will
Sounds good.
conclude the task
Thank
force
you all.
meeting for today. Thank you
Thank
very
you.
much.
Good
Dave.
job.
Good job.
That'll work. Thank you.
Good stuff.
We are complying. Business is